Yes.
My lord, I am mentioning.
Inclusion, please come on Wednesday. Please come on Wednesday.
Direction of the order, my lord.
Correction, hand over the slip.
May I be permitted to mention what matter, my lord? This matter was mentioned by
What do you want?
restoration application.
Please come on Wednesday.
Friday, you have directed to appear this matter today, my lord. It is not appearing, my lord. That's why, my lord, it's a very urgent matter.
Yes.
Matter was directed to appear today's list as contested, not appearing in the list. Order is there.
Contested, it's not possible now.
No, my let it be in the list, my lord.
My lord,
My lord.
Contested, it's not possible
In the
now.
monthly list, my
No,
lord.
no.
is appearing,
Contested, yes.
matter is appearing on the monthly list. There is an extreme.
What do you want?
My lord, the petition.
What do you want?
Urgent, imminent
Please come on Wednesday.
dispossessing from his property, my lord.
Please come on Wednesday. Yes, call the list. Yes.
Yes, lordship. Interim order passed 3/9/2024 earlier. Another bench, lordship.
Interim order passed on?
3/9/2024, lordship.
Yes.
After expired December. Lordship, during pending of this application, I file a extension interim order application, file an application, lordship. Several locations mentioned before this court, but that is not listed.
When did you last mention?
Last mentioned earlier.
When? What is the date?
Lordship,
When did you last mention?
last
Please put the date when you have last mentioned. I will verify that.
last
Please
one
put
is
the date when you have last mentioned.
last one, Mr. Partho Sarthi Basu is mentioned this matter.
Please put the date when it was mentioned.
Last mention date.
Please put the date when it was mentioned. I will consult the file. All mentioning slips are there in the file. I will verify whether you have mentioned on that date. Please mention the date.
Lordship, December, lordship, 2021. Lordship, I file a CAN application, lordship.
Say so. You have said no extension of interim order. All matters which were mentioned for extension of interim order.
Matter is connection, lordship. I am the applicant, lordship. I am withdraw this suit and file a fresh, lordship. That is the main allegation. I am a plaintiff of the court below. Evidence written statement already complete, lordship. Some of the day.
So you want to withdraw the suit?
Withdraw suit and file a fresh application.
So where is the difficulty?
Liberty may given to file a
There
fresh.
is no interim order.
No,
Interim order has expired.
Lordship, 1 minute, lordship. Otherwise, the suit is plaint is very defect plaint, lordship. First lawyer file amendment petition, thereafter defective, lordship. Lordship, in the meantime, lordship, all evidence, all such written statement also complete, lordship. But new appointed lawyer that check this, the pair and all such portion of this plaint is disputed, lordship. I am withdrawn this application to file a fresh application. File a fresh.
You want to withdraw which application?
Main suit I have.
Yes, so where is the difficulty? You approach the law trial judge.
Trial judge set aside and date for evidence, lordship.
Yes.
I am withdrawn this suit and I file a fresh, lordship. And liberty will mention.
So you have filed an application?
Extension, I have filed.
Yes. Yes.
Otherwise, lordship, he started trial.
Please come on Wednesday. Upgradation, new inclusion. Please come on Wednesday. Expeditious disposal. What do you want? It's appearing in the list. So,
And my lord, another application that is your lordship has.
sir, you want inclusion.
Inclusion.
So please come on Wednesday.
The matter is for release the matter, my lord. As per my client direction, my lord, I want to release this.
Why? What is the reason?
My lord, the earlier occasion, the matter was taken up before the Honorable Justice Shampa Sarkar, and the returnable date was on 17 June 2024. My lord, till date, the matter has not been taken up.
Have you mentioned
Yes,
this matter? When did you last mention? Please mention the date of mentioning, last mentioning in the mentioning slip. Yes, call the list.
Item number 1.
Come on Wednesday. 1 to 2 p.m. fixed. That's it.
Lord, I appear for the petitioner. But there is a caveat I have served already. Lord, may I just please?
Yes, who is for the caveat?
Millard, actually, I'm led by
You have served.
Yes, I have served. I have served.
Millard. I'm
For
led,
the caveat.
yeah, Millard.
Yes.
Millard,
Yes.
led by Mr. Chaturvedi. I'm led by Mr. Piyush Chaturvedi. I
Yes.
believe that he's on.
Yes.
Lord, the fact of the case in short is this, my Lord. The plaintiff, the defendant here is the petitioner. Plaintiff filed a suit for eviction against the defendant. And PW1, the plaintiff's witness, is over, both examination chief and cross-examination. Subsequently, my Lord, he filed an application under Order 18, Rule 4, not 17.
Order 18, Rule 4.
Rule 4.
For
Praying for with a supplementary evidence in chief and to allow that
where is
application.
that application?
That application is allowed, we have not contested. The second
Okay.
application, that application regarding only to enclose an exhibit of a postal receipt and the track report. So we have not objected. Second time he has filed another application under Order 18, Rule 4, praying
Under Order 18,
Order
Rule 4.
18, Rule 4, praying, my Lord, to include a document that
Where is that application?
Yes,
Show me
that-
the impugned
page,
application.
page 44.
44.
Page 40. That is their application, second application. That is the board resolution.
Yes.
And we have filed our written objection. That is at page 48,
Yes.
saying that this cannot be permitted because this is to cover up the lacuna at a delayed stage, and the landed judge, after hearing, allowed that application and rejected my application. My main contention is this, my lord, that by way of a supplementary affidavit, they are trying to cover up their lacuna, which they cannot under Order 18. Even if it is under Order 18, Rule 17, this is not 17A is now abandoned. So under Order 18,
17A has been omitted.
omitted.
If 17A was, by virtue of 17A, it could have
So
been permitted.
under Order 18, Rule 17, there is no scope for
It's the
filing.
court's requirement.
That is true. That
It's
is
only the court's requirement, but not at the asking of the party.
but
That is your submission.
Milord, I have more some submissions. Milord, first of all, Milord, our main submission is this, Milord, that that this document, what they are trying to, that is a board resolution. The suit was filed by one of the directors, but the person who was given evidence is an authorized representative of 2012, and there is no whisper in the plaint, in the evidence in chief, or nowhere about that board resolution. And they have said in this petition that although this document was lying in their custody.
No, where is the application praying for recall of PW1? Where is that application?
That application for recalling of the.
Court has said plaintiff has filed a petition with a prayer to recall along with the supplementary affidavit in chief.
Yes, yes.
You have only annexed the supplementary affidavit in chief. You have not annexed the copy of the recall petition.
Recall petition.
Yes, Mr. Chaturvedi,
yes,
you have a
possible.
copy of the recall petition.
Yes, yes, yes.
Page
Page 43, 43.
43. You said only this application was supplementary affidavit was filed. I asked you.
That is at page 43. That your petitioner wants to file a supplementary affidavit in chief in respect of the documents filed before and court, that it is necessary to file the supplementary affidavit in chief to exhibit the document filed before this learned court.
Yes.
And this is the application.
So that was allowed. At what stage?
Only the PW evidence is completed, chief and cross. This document was with them, and this is an old document. My whole cross examination will.
So according to you, it's for filling up the lacuna in evidence.
And I have brought the judgment of this Honorable Supreme Court.
Place the three judgments of the Honorable Supreme Court.
এটা একটা নিয়ে নিন তো, এটা একটু যশোর। Lord, I shall only place the relevant paragraphs. This is a
This is Vadiraj Nagappa,
Justice
2009,
Justice Arthamaskovi's judgment.
2009, volume 4 SCC.
Your Lordship knows that. Although it is not.
No, you have not given that.
No,
SCC.
no,
I think 2009, volume 4 SCC.
that is taken through online.
Considered this judgment in the judgment delivered inter se the same parties.
But
There are four suits.
my lord, there are forces, but here.
I shall address.
Acha,
I
Yes, yes.
But here the case is different. Here, my lord, we started only examination chief was over. We started cross examination. That is why Lordship disallowed my application. But here, my lord, after completion of both the evidence, chief and cross, now they have come up for the first application.
Yes, this is one. What are the other judgments?
Paragraph 16, my lord.
Paragraph 16.
Lordship, Charlie may note it. Towards the middle, my lord, it is obvious that only after cross-examination of the witness that certain lapses in evidence came to be noticed, which implied the appellant to file the application under Order 18-17 of the CPC. Such a course of action which arises out of the fact situation in the case does not make out a case for the recall of the witness after the examination has been completed. This part matter I am relying. And that the power under Order 18-17 CPC is to be sparingly exercised and the appropriate cases, and not as a general rule merely on the ground that his recall and re-examination would not cause any prejudice to the parties.
Yes.
That is number
What is the
one.
next decision?
Yes, the next. That is also Supreme Court judgment, my lord. এটা আগে দিকে দিয়েছি। My lord,
This is the latest one.
yes.
This is the latest one, which relies upon 2011, volume 11. Where is that? This is the latest decision. It relies upon 2011, volume 11. You have not brought that?
No, that is not.
I have a copy.
Oh, they have a copy. My lord, I am placing, my lord, paragraph 7.
You have not brought that. That is some observations in that is against you. That is why you have not brought.
But my lord, the Supreme Court's main contention is this.
Yes, any other decision you want to rely upon?
Yes, that-
Yes, here which paragraph you want to rely upon?
Paragraph 7, 10 and 11.
7, 10 and 11.
Yes.
So you will not rely upon paragraph 12.
12.
Paragraph 12 we will not rely upon.
No. May I just read it out then. If your lordship feels that this is going against me, I can read it out.
12 is reiterating 2011, volume 11, which I was saying. Yes.
My lord, the last one is.
This is what is the reporting? Bagai construction.
Yes.
I think Bagai construction I have also considered.
Yes.
What is the reference, Mr. Chaturvedi?
High construction is AIR 2013 Supreme Court 1849.
Year 2013 Supreme Court page
1849.
1849. Is it equivalent to 2013-14 SCC page 1? Please verify.
AI.
Yes, any other decision?
Yes, no, sir, I have placed another one.
Yes, yes.
The
This Bagai construction.
paragraph 12, my lord. I am relying on paragraph
Paragraph 12.
Yes.
Yes,
12, my lord.
I think I have considered this judgment in the other
But
matter.
my lord, facts of the case is the earlier matter, although it is within the same parties, but the facts of the case is.
All right, any other decision you want
I
to
am
cite?
not placing.
Yes, Mr. Chaturvedi.
So, my lord, my submission is this: by way of this way, recalling of the witness, they cannot cover up their lacuna.
Yes, this is 2011, volume 11.
Which one, my lord?
No, এটা কে দিল?
That was
Mr. Chaturvedi, why are you rely upon the decisions of from Monu Patro? Some
yes,
sentences, some words are missing.
yes. Blood the citation, blood of AIR, my lord, and Supreme Court cases is also there.
That is 2000, I think 2011, volume 11 SCC, page 275.
My lord is referring to Veluswamy.
Yes, KK Velusamy.
Veluswamy, my lord, is there, my lord, 2011.
Yes, you have handed up KK Velusamy.
Yes,
Any other decision you want to rely upon?
but I intend to rely my lord's own decision, where my lord considered. Take to the conference. Lord kindly comes to internal page 2 of my lord's order. Lord, the second paragraph,
Yes,
Lord, 2009 volume 4 SCC, Vadiraj Nagappa was considered. Then Ramrati, my lord, was considered.
Ramrati is the latest one.
No, there is, my lord, another one, my lord, which is latest.
Oh,
Uh,
yes, Ramrati versus Mangeram. Then Bagai
Bagai
construction
was considered. And then kindly, my lord, turn up. Lord, Veluswamy and Shubkaran Singh. This Shubkaran Singh is the latest one. This is why,
delivered by Justice Patiwala.
yes.
Yes.
So my lord considered all this, and then my lord considered my lord's own decision rendered in Jadov Electric.
Yes.
That is at page internal page 3. And then, Lord, your lordship, my lord, arrived at a decision. Marking করা যেতে ছিল। Lord, kindly, Lord, kindly sees, Lord, paragraph page 5.
Yes.
Lord, kindly sees in second paragraph, my lord has observed the Honorable Supreme Court in a recent decision in the case of Shubkaran Singh reiterated the
Proposition laid down in KK Velusamy because that was quoted in paragraph 12 only.
Yes.
And
And then the fourth paragraph, after going through the materials, on record, this court is of the considered view that the learned trial judge was right in allowing the prayer for recall of PW1 by order dated 8 January 2025, as the same was necessary for the purpose of rendering justice. That apart, the order dated 8 January is not a challenge. Then,
in that case, Mr. Chaturvedi, the recalling was earlier allowed. In the earlier.
cross-examination
That was not challenged also.
right.
But now, what's the relevance of those documents? Please show me that.
I come to them. Kindly, my lord, sees. Then my lord arrived at an independent, my lord, view apropos the necessity of these documents. My lord, kindly sees the next paragraph. The learned trial judge.
Yes.
The learned trial judge, by order impugned, rightly noted that no new case has been made out by the plaintiff by producing those documents in cross-examination. The service of notice was also not denied by the defendant at any point of time. So one document was that I had not exhibited the Xerox copy of the postal track report. I intend now, my lord, to rely on section 65B of the Evidence Act and the certificate.
That was in the earlier matter.
Yes, identical matter.
This matter also same thing.
No, certainly not. Certainly.
Yes.
Sorry.
Yes, yes.
Board resolution and the certificate. These are the two things. There are 4 my lord suits inter se between the parties, where my clients, my lord, are the plaintiffs and my learned friends' clients are the defendants. And both the suits.
I think in the earlier matter also board resolution was the issue
yes,
also.
Yes. I shall show, my lord.
My lord, that application was
Then, my lord, then discussed Bagai construction. Then Ramrati. And then my lord, dismiss, my lord, the revisional application. Now, kindly, my lord, takes up the revisional application.
Yes.
Lord, kindly sees the document which I intend to, my lord, kindly comes to page 47.
Yes.
Lord, this is, my lord, filed by way of a fiduciary, which is at page 46.
Yes.
Now kindly sees, this is the board resolution which, my lord, is intended, my lord, to be filed, and this says, this is of.
So
second-
these you sought to incorporate by way of evidence.
That's all.
And any other thing? No.
In this,
It's only the board resolution.
no, one moment. Coastal traffic court was here.
My lord, there is no whisper about this document, either in chief or in the plaint. This is absolutely a new document they are trying to.
Kindly comes to page 41.
Track report of the postal receipt.
That
Page
is allowed.
41.
Page?
41.
That is allowed. We have not objected.
Yes.
This is not the certificate. This is to certify that a notice letter dated was sent on behalf of.
Postal receipt.
Yes,
That is 65B.
my lord.
Compliance of 65B.
Yes. These are the two documents, and these were the two documents in the other divisional application which was
But
considered
what
by
have
my
you
lord.
stated in your application for recall, Mr. Chaturvedi? Have you seen your application for
No,
recall?
it does not. But my lord, then court, my lord, was doing complete justice, and court was considering.
Even without you making out a case in the application.
My lord, applications, my lord,
Please take up page 43, your application. What does it state?
it's not really happily worded. My lord, and my lord took this view in.
Not happily worded is not the correct expression. There is no word itself on that.
But my lord,
Happily is that word is there, not happily.
but my lord, kindly sees, my lord, the court, my lord, weighed, my lord, the balance. Court was balancing the equities. The court
You
was
have said to file an exhibit a document. Only that is the one sentence in the. Is it a way to draft an application for recall of a?
It could have been, my lord, it could have been better elucidated. It could have been, there is no doubt about it. And I said the same, my lord, made the same submissions before my lord on the other day. What persuaded my lord was that, my lord, the observation and the conclusion of the learned trial court was that the court was doing complete justice and that no prejudice would be suffered by the
Anything more?
nothing.
Yes.
Only Order 18, Rule 17 provides only to clear any ambiguity. But this is a very vital document on the basis of which the plaint was filed by one of the directors in 2017. Now, my lord, the person who is PW1, he is only an authorized person. Now he is trying to bring that document in the record, and there is no pleading in the plaint or in the examination chip about this authority and how he has authorized. He has authorized, said, I am authorizing by filing my authority under as per 2012 document. But this is an old document. My whole contention regarding cross-examination will invalid, because when he found that he is caught, then he have come up with the, and in the first application, first evidence in chief, the supplementary affidavit, they have already exhibited one document, that is the track report. To that, we have not objected. But to some of this application is concerned, we have filed written objection, and we are objecting to this. This cannot be done by this process. That's
This application under Article 227 of the Constitution
Or item 3, I appear for the petitioner. My lord, in a application seeking alimony pendentity, my lord, the husband is the petitioner before your lordships, challenging the final order. My lord.
My lord, I'm for the wife. My lord, may direct him to give me a copy, my lord.
My lord, I shall.
Yes, Mr. Chaudhary, 10,000 has been awarded only.
10,000, my lord, with the reason, my lord, the husband earns 20,000 rupees per month and the wife left the matrimony on her
Your income,
but source of his income is, my lord, a freelancing dietitian. He performs dietitians he practices into the dietitian arena and performs freelancing activities.
self-employed. or you are
Self-employed.
Employed.
Self-employed. My IT returns were filed.
Find your affidavit of assets and
My lord,
liabilities.
my lord, at page 60 of your lordship.
60.
60.
Yes.
My lord, 60.
Not paginated, Mr. Chaudhary.
My lord, I tender my
Which
apology.
annexure? D.
My lord, annexure D.
Yes.
My lord, I have.
You are Somendu Ghosh.
Yes, my lord.
Yes.
My lord,
Show me that portion.
my lord, this at internal page 4 of my affidavit,
Yes.
details of income of the deponent.
Yes.
My lord, I have said, my lord, I have earned 20,000 rupees per month. With this, my lord, I have filed the
And what is the expenses, monthly expenses of yours?
my lord, monthly expenses I have narrated at my lord, internal page 2.
Yes, quantum of monthly expenses.
My lord, it's coming around, my lord, count of the dependent. My lord, it's quantum of expenditures.
Monthly expenditure,
Expenditures at page
9,000.
9,000 rupees on the dependent mother.
9,000.
Yes, I have a
Total expenses per month.
my lord, I have it is not narrated here.
Yes.
It is
And
not narrated here.
show me your income tax returns. You are regularly filing
My
income
lord,
tax
on
returns.
the honorable the learned court have examined such income tax return. It is not appended to this petition. My lord, kindly takes up the order.
So from the income tax returns, the particulars which have been given can be clarified by this affidavit of assets.
My lord, the income tax
Because
return.
20,000 is your monthly income.
Yes.
9,000 you are spending towards
My
the
lord.
mother.
My lord.
And how much is your own expenditure
lord,
per month?
My lord, the learned court has assessed this point, my lord,
Yes.
wherein, my lord, at page the internal the kindly takes the interim order at
Yes.
paragraph 12.
12 years.
12, it's my lord, just the paragraph, the next page,
Yes.
some lines above paragraph 13.
Some lines above paragraph.
But
13.
IT return submitted by the opposite party, it has been gross annual income such and such, kindly takes up, my lord, the assessment year of 2023 or 2024.
So you are a professional.
I am professional.
So these income tax return is after excluding the expenses, professional expenses.
My lord, I need to, my lord, my lord, show that before your lordships.
No, I'm
before your
asking you
lordships.
because the professional, if you are a professional self-employed person from income, you are entitled to certain deductions. Under
Yes.
Section
Well,
37 of the Income Tax Act.
I need to check that.
So after that is your
Well, I need
income,
to,
which is
well, I have followed
taxable,
your lordships.
which is-
Well, I'm following your lordships, but I need to check that.
Mr.
And my lord-
Chaudhary,
And my lord, two important facets of this case. My lord, the petitioner after,
if
my
you produce that, it may be enhanced, Mr. Chaudhary.
lord,
Don't
my lord,
take that risk.
no, my lord, I am not taking that risk. My lord, I am just before your
10,000
lordships passes any ordinance,
is your income.
but before your lordships,
Show me in the affidavit of assets, where have you stated that what is your source of income?
Something else written, my lord, in paragraph 7.
Sir, please, you don't have a copy. Please take your seat. Please take your seat.
no, lord, just
You have not lodged any caveat.
no.
Please take your seat. Yes.
My lord, I will not take your lordship's valuable time, my lord. I need to check that, my lord. I have, my lord, it has omitted my,
It's not there.
but just,
It's not there.
points, just 2 points before your lordships passes any order. First, within 3 months of marriage in 2018, the wife left on her own volition. She is a teacher, she is working.
Show me that you have proved that.
It is there in her affidavit of assets itself. And my lord, in the petition, she has urge that she earns a monthly income. She has a monthly income.
What is that monthly income?
8,200, 2,500 as per her intentions.
So
Having her
8,000.
flat.
Mr. Chaudhary, it's not sufficient. Because your expenses on mother is 9,000. So apart from that, you have your own expenses. This is your own admission that you are spending that.
Yes, yes, it is there.
So
It is
on mother is 9,000 and your expenditure you have not stated.
Or it is not
So
there.
to 20,000, it's
And-
very hard to believe, Mr. Chaudhary.
And kindly
Yes,
consider
yes,
the income of the wife also. My lord.
Yes, yes.
She is also earning and left her own matrimony on her own volition, my lord. And no allegations of
ground. Show me that that's the ground to disentitle a wife alimony under section 36 or 24.
and
This application under article 227.
definitely.
আচ্ছা আর একটা লিখে দিন
And for the petitioner,
yes sir, what is the order under challenge?
the Lordship, I to grant serve copy on the other side.
Why sir, what is the order impugned?
The order is the order that has been passed by the judge, the status quo. Posted application or order that it has to title so.
The certified copy, otherwise you cannot file that.
Lord, whether Bastu land is preemptable or not, Lord, a special bench, Lord, I pray for action.
Mr. Banerjee, Barasat Eye Hospital is staring at your face.
No, a special bench has been constituted.
What will be done?
Lord, I
A
will,
special bench, Bastu, this
Lord,
way,
I will pray
that
for,
way, Barasat Eye Hospital.
that's right, my Lord.
So, nothing.
Lord, one thing, my Lord.
Bastu,
No, one thing, Lord, I pray for adjournment.
Mr. Banerjee, it's not a case. If Barasat Eye Hospital, short consideration, no dispute.
But on that point, he did not go, my Lord. First of all, the
Did not go.
no
Please kindly come to the appellate court's order,
appellate.
page 3,
No,
last paragraph, page 4, first paragraph.
No, first of all, kindly come to page 53.
Mr.
Two
Banerjee,
times remand.
is maybe, but this is the ultimate finding. Is there any short consideration? What is the consideration as per the deed? And what
What
is the
consideration, my Lord, a special bench. Lord, I'm not on that, my Lord. I'm praying for
Is the
adjournment.
preemption on the ground of co-sharer or adjoining owner?
Adjoining owner.
Adjoining owner, no reference. It's on co-sharership. This application under
Lord,
article.
your Lordship grant an adjournment. I am praying for
Mr.
adjournment.
Banerjee, there is
I
nothing.
know, my Lord, that if I argue, my Lord, my petition will be rejected. I am candidly saying, because in other matters, your
I'm
Lordship.
recording that you have prayed for adjournment, but I am recording this fact on for which I am rejecting your prayer. Mr. Banerjee, there is nothing. Unnecessarily,
Two times. First time, my Lord, it is not applicable.
Mr. Banerjee, what can
Lord,
you short consideration is staring at your face.
may I tell you, Lordship, may I tell you, Lordship, the facts? Lord, when the preemption application was filed, they did not raise this question because at that time law was that. At that time, short consideration can be deposited and preemption can be secured. At that time, my Lord, a point was raised before the court that in Howrah Municipal Corporation Act, this is not applicable. WBLR Act is not applicable for preemption. Court held not applicable. Appellate court held not applicable. Then this court entertained it. Then it was gone to tribunal. Then tribunal, after the judgment of the division bench, then tribunal sent it. Then, my Lord, ultimately, Lord, order was set aside, held that it is applicable. Then, my Lord, the second point was it was remanded. That second point was that it is a Bastu land. That point, my Lord, that is Bastu land not maintainable. Then, my Lord, ultimately, your Lordship kindly look to page 53.
Yes.
Lord, remand was only to this line. That point.
But if it is not maintainable, Mr. Banerjee,
But this was not it, blood remand was.
ex facie, it's not maintainable in view of the Supreme Court judgment. First. Second, it's not a declaration which is to take effect from the date of passing of that judgment, as in Patil automated.
No, because
automation
this is the question.
12A.
Lord, this is the question, my lord, which is required
Mr.
to be
Banerjee,
decided.
Mr. Banerjee, you know, when a Supreme Court declares something, so it says when it is to be taken effect to, as in section 12A of the Commercial Courts Act. This is not a case. In Barasat Eye Hospital, do you know what happened? In that matter also, it was not allowed.
No, so far, my lord, my
In that
submission,
matter also,
Lord,
up
my
to
submission is,
the preemptor one.
Lord, my submission is very candid. I do not want to argue because I have no point on the basis of the last. That is why I pray for adjournment. Let us try my luck. Let us try my luck. Lord, 2 times remand.
What
2 times
luck,
remand.
Mr. Banerjee?
Lord, 2 times remand, 24 years past. Lord, harassment is like this. Lordship, kindly
I think this
consider
will be
this
the
as
end of the harassment.
this is the end.
This will
Lord,
be the
that
end
is
of
why
the harassment.
that is
Otherwise, keeping pending will be much more
that is
harassment.
why, my lord, considering that fact, my lord, I am not paying any interim order. Considering that fact, adjournment to be granted.
Since Bastu is pending, since the special bench on Bastu is pending, I'm recording your submission.
Not only that, also the conclusion of the appellate court not with regard to Bastu, conclusion of the appellate court below was short deposit.
Yes, so it goes to the root of the jurisdiction of
He has
the court
gone to the root of the jurisdiction of the court.
to entertain that
But in
application.
the event below, the special bench decides.
Cannot, because that is this is of vicinage, that is on co-shareship.
No, on the ground of co-sharer, possibly, my lord.
Vicinage.
No, on the ground of co-sharer.
Show me.
my lord. Possibly, my lord.
Show me the preemption application.
Let me look into that, my lord. Lord, page 16, my lord.
Yes. Show me the ground that you are a co-sharer.
That is why I am.
Paragraph 5, adjoining owner.
Any other, Lord,
Paragraph 5 is adjoining owner, Mr.
that is
Banerjee.
adjoining owner,
Yes.
co-sharer or either.
It's not a case of co-shareship.
No, that is why I'm looking into it, my lord.
Yes.
If
Please
I don't
satisfy
find,
me
I
that
will-
is on
I will
co-shareship.
submit before you.
And even then, co-shareship, Mr. Banerjee, after the Supreme Court judgment, it's difficult.
Lord, a special bench judgment is also 76 CWN.
What?
With regard to co-sharership, that is vested.
Maybe, but show me your pleadings. Show me your pleadings with regard to co-shareship. Your preemption is on the ground of vicinage.
Paragraph 9 also vicinage.
Yes, everything is on
Lord, your
vicinage.
lordship kindly adjourn it.
And you
for a month,
prepared yourself on the ground of vicinage.
because the special bench will be
Uh,
sitting, my lord, in the last.
Special bench is on, show me the points of reference of special bench. It's on co-share.
Lord, let me adjourn for the
Could not
day.
have been,
So to
Mr.
tomorrow I
Banerjee,
shall come back.
could not have been on vicinage because Barasat Eye Hospital is on vicinage.
On a co-sharer.
Barasat Eye Hospital was on vicinage. This is also on vicinage. Vicinage, there cannot be any reference.
Vicinage, my
Even
lord,
if
on
there
the
is a
ground, there was,
I'm bound by the
vicinage, there was no reference possibly.
Where?
Vicinage, there was no reference.
Yes,
possibly.
that is why. So Supreme Court is there. Your case is also on vicinage. That is why I'm saying. Reference is on co-shareship. That is why I'm saying. Short consideration reference cannot be on vicinage because Barasat Eye Hospital was on
Because
vicinage.
of the co-sharer.
Barasat Eye Hospital was on vicinage because I appeared in that matter.
Yes, Barasat High Hospital was on vicinage.
This application under Article 227 of the Constitution of India
Unfortunate lack of
Cannot be done.
litigation cannot be done.
Because in Barasat Eye Hospital, Mr. Banerjee, I tell you, up
Thereafter,
to
2022 में another
thereafter
judgment.
also no liberty was granted to put in that amount. Look the plight of the preemptor who won his high court, saying that no, you need not have to deposit. Even then, on the ground that the limitation has set in, it cannot be cured. As in your case, you cannot be also allowed to deposit that. Yes, Mr. Mukherjee.
But I am the plaintiff in a suit for eviction. I filed a suit for eviction against the original tenant defendant. Now, the defendant chose not to appear when the suit was matured for hearing. But the wife and the minor daughter filed an application for addition of party in that suit, saying that husband is missing. Now, that application for addition of party was allowed by the learned trial judge. I came up before this court. Now, this honorable court, I produced the document showing that husband is.
The husband appeared in the suit.
No. Received the summons, choose not to appear. Now, the wife and.
What is the endorsement in the summons, Mr. Mukherjee? What was the endorsement in the summons?
But that I. Now I can't say what is the endorsement. Now what happened?
You can't say.
What?
You can't say what was the endorsement in the summons. You said that in spite of service.
Absconding. What happened, the husband.
The summons it was said absconding. Unheard of, Mr. Mukherjee.
In summons it has not said. Summons.
I'm asking you.
Summons.
What is the track report in the summons?
After the coordinate bench judgment, subject to correction, this point has already been decided by this honorable. May I just take?
No, when you said that after summons, I asked you, yes, you proceed thereafter.
Now, what happened, that the story was made that the husband is missing, for 4 years. Now, I said that.
Is anyone in occupation of your suit premises?
Yes.
Who is occupation?
Now, at present, no one, because it is a shop room. It is a shop room. The wife and daughter is residing in different place. Now, they are saying that they are also, as the husband was the tenant, they become also the tenant. Now, what happened, now in that.
Now, what is the impugned order?
I'm coming, come, give me 2 minutes. Now, what happened, in the revision application, direction was given for exchange of affidavit. Now, they filed opposition saying that, in my division, saying that husband is missing. I filed a reply stating that some person lodged a complaint before the local police station saying that husband has siphoned the money and it is his habit. And my police submitted report, he is residing in other state. Now, it is known to all the parties. Now, considering all the aspect and the judgment that the relationship between landlord and tenant, this honorable court rejected the application filed by the wife. Now, and not only that, only permission was granted. If your lordship kindly.
So according to you, Mr. Mukherjee, the wife and the son is a third party to a litigation.
Absolutely, that is a finding.
Not a necessary party.
Not a necessary party. That is
not be included in the suit.
Absolutely.
But in order 21, they have a right.
I'm coming. No, order 21 will come if they don't file the separate suit. They have filed, the wife and the daughter has filed a separate suit for declaration injunction. That has been dismissed. And may I just, in respect of self-same property. Possibly I'm not clear before.
Yes.
Now, kindly turn to the judgment of this honorable court, page 20 starts from.
Yes. Now, what is the impugned order?
Unless your lordship sees this order, impugned order is what happened ultimately suit decree. Suit decree. Now, this particular wife and daughter filed an application leave to prefer an appeal. That was allowed without considering the suit filed by the wife and the daughter has been dismissed on merits. And not only that, the lower appellate could reserve the opinion.
To prefer an appeal was a contested one. Leave to prefer an appeal was allowed after hearing you or without hearing you.
No, if your lordship see once, page 19.
No, I'm asking you, after hearing you or without hearing you?
After hearing.
Show me your submissions.
But ওদের সাবমিশন আছে ওদের না এটা ঠিকই বলেছে আমরা দেখিনি ওটা আমরা অ্যাপিয়ার করেছি কিনা that I can't say right now whether it was allowed expertise or not, but kindly see the observation once. But as if High Court has permitted to cross-examine. Therefore, she has the right.
Mr. Mukherjee, if you have not contested that, I will give you liberty to file an appropriate application there.
I mean, kindly see one.
And if you have contested, show me your contention there.
May I just kindly give me 1 minute. Memorandum of paper, Pradeep ka GS sir short phone kore. But kindly before that, kindly come to the order of this honorable court, my lord. Page 27.
So see, this was a contested or an uncontested
Kindly
one?
give me 2 minutes, my lord. I'm telling. Just send for instruction. Kindly take page 27.
Yes. What is page 27?
Page 27 is a part of the order of the Honorable High Court, but starts from page 19. This is a page 19. It
You
starts
place the entirety of that.
or not. That's why I'm telling your lordship, kindly see page 27, from page 27.
Yes.
Section. However, the Honorable Apex Court in Modular India, considering Modular India, but held in a suit where the defense was struck up or was proceeding undefended, the right of cross-examination of the defendant could not be denied. The defendant had a right to cross-examine the plaintiff on the plaintiff's case without setting up a defense or by making submission beyond the plain case. Section 122 of the Evidence Act provides that in all civil proceedings, the husband or wife or of any party to the suit shall be competent witness to each other. Thus, the only relief can be granted to the opposite party wife is the right to cross-examine the plaintiff on the plain case without setting up any defense of her own. Such cross-examination is allowed in view of the provisions of law that the wife can be witness on behalf of her husband. The opposite part number 1 will have the right of cross-examination. Impunity set aside. Now, and I have taken the instruction, it was a contested. And
Show me your contention recorded there.
Appeal.
Show me, Mr. Mukherjee, what was your contention before the appellate court?
By appeal court, no submission has been recorded.
Then, if it is according to you that you have made submission not recorded, remedy lies elsewhere.
I'm on the law point. Suppose today I have not argued anything. Kindly see the finding. Kindly see the finding.
Mr. Mukherjee, then I can give you liberty. You can take appropriate steps.
But kindly see
before the learned,
kindly see one line.
before the learned appellate court, even for recalling of that leave.
But kindly see one line. Kindly see.
Yes.
But what is the reason for allowing this application? Kindly see. However, the Honorable High Court allowed to contest the suit. However, they were not allowed to place their own defense. When the cross-examination is allowed, it does not preclude the right to prefer an appeal by the appellant. But this is absolutely wrong and misinterpreted.
What is the purpose of allowing a party to cross-examine?
But he can, I'm telling you.
If a party can cross-examine, demolish your case. Demolish your case.
Demolish.
Yes. Demolish within that limited. So what is the right? She does not have any right.
But had it been the case, she should not.
That is why I'm saying, if you have not participated, I can give you that leave. And if you want me to decide, I will decide.
Can you kindly take at 2 p.m. Only that instruction I have to take whether that has been contested or not.
Even if it is according to you, it was contested, nothing recorded. So remedy lies elsewhere.
Kindly take
Yes, what is your instruction?
Instruction is contested.
Contested, but not recorded.
That now, kindly see. Order 21 to 97 will come if the party has not.
I'm not on order 21.
No, when you lordship.
I'm on this. Leave.
Now, her own suit has been dismissed. Kindly visualize that position. She not only filed an.
All those facts, nothing has been stated there, Mr. Mukherjee. I can give you that leave. If according to you, you have made submissions, nothing on recorded has been recorded, I cannot say that from here. I cannot also take note of your that contentions and pass an order in
but
this.
If your lordship see once the finding, if I put this question to myself, this finding that High Court permitted, why High Court permitted, that has been clarified. Your lordship has seen that.
Mr. Mukherjee, what is the purpose? Who will be allowed to cross-examine?
But cross-examination, the lady, the wife can be a witness on behalf of the husband. Now, that liberty has been granted.
What circumstances?
Because they are.
Under what circumstances?
But that has not been clarified.
I am asking you. I'm not on the impugned order. I'm asking you because it's your submission that the wife, she was permitted to adduce evidence as she is the wife for the husband. So I'm asking you under what circumstances.
Then for that reason, the lordship has to go into the plaintiff case. What is the suit for? If I say the suit is for eviction, Now, your lordship knows in a suit for eviction when the jural relationship is the main contention, here that has been considered. If your lordship see the entire judgment of the coordinate bench, your lordship will find that point was argued that they have a right that has been turned down. They did not challenge before the higher forum. Now, my lord, what happened, my lord? They have been cross-examined. Now,
What do you want? You want to go back or you want this point to be decided
kindly
here?
clarify that, my lord.
What?
But regarding if I go back and file this application, but
You said that you have made submissions that was not recorded. For that you have to.
that's why, my lord, I'm telling. Although my lord, instruction is, my lord, I've made submission, but from the here I could not find anything. Kindly takes up at 1 or 2 p.m. Just that to that extent, nothing more.
Already you serve a copy upon the other side.
That will delay the process. Because ultimately, my lord, kindly visualize eviction.
That is why, Mr. Mukherjee, I am asking you, delay. You do not do now at this
Delay the
stage.
process. That
You are
will-
trying to avoid some person. You don't know what will happen afterwards. That
Oh,
is why I
that-
tried to
They can't
impress upon you. You are going to order 21 rule 97.
because there is from their own suit.
You are going, I am telling you. You are
No,
going to order
It is
21 rule
suggestion.
97.
Is the, my lord, feelings from your lordship's court, the order 21. But if they file a suit and suit has been dismissed on contest, they did not challenge. They were subject to correction. Order 21, they can't take the help. This is number one. Number two, this only to that portion whether I have made the submission. Kindly keep it at 2 p.m. Only for ultimately I will go because
There is a special fixed matter.
or 1
I can
PM, one.
I can direct you to serve.
But regarding that will cause a delay. That will cause a delay.
Yes, has to be. There is no caveat, Mr. Mukherjee. There is no caveat. Even if you take instructions, then also this will happen.
I will pray for.
I cannot allow you on your submission. I cannot set aside this order.
I'm not.
It has to
Kindly
be.
grant stay.
I'm admitting.
Kindly grant limited stay of the title appeal.
What?
Title appeal.
Or as well as the operation of the judgment and degree of the trial court. That has to be done.
23rd July is the next date. Kindly fix it after.
So I'm also staying everything, suit as well as the operation of the judgment. You cannot in the meantime.
That is going against me.
Execute the decree and make the appeal infructuous.
That can't be.
Petitioner is directed.
Kindly do one thing. I've fallen what is fallen from my lordship. But can it be before 23rd July? So that I will
assure you.
Well, I will only pray for early disposal of the appeal in that case. I will only pray for early disposal of the appeal because since 2001 I'm moving.
Pray that I'm granting you that. After some
Item 7 for the petitioners. This is for expeditious disposal. It's a matrimonial suit filed in 2006.
Who are you?
I'm the husband and the applicant therein. Wife is the opposite party.
Any miscase pending?
Miscase is not pending, my lords, but one amendment of written statement is pending.
Any alimony order has been passed?
Yes, my lords. Kindly check page 34. I have also paid.
Page 34. You are paying.
34. Page 34 is the proof that I have paid, and now currently my instructions are I am paying.
Under what proceeding? Maintenance alimony under what
This
proceeding?
was under section 24. The application was made by the wife. Thereafter, I am paying around 30,000 per month. The only difficulty is, my lords, it has been pending since 2016 when I was 36 years old. Now I am almost 45. Now, practically speaking, my lords, if I am to ask for a second marriage or something, it's becoming very difficult for me because the evidence of the wife started in 2000. My evidence started in 2019. That has not been concluded.
Your evidence started?
Yes.
This application is under order 617.
Wives, opposite parties. That is also pending.
This application under article 227 of the Constitution of Opposite party, yes, Mr. Bhattacharya. Not today. Yes, Mr. Bhattacharya.
This is that matter. Your Lordship's Miller passed an order at page 172.
What wrong order I have passed?
No, not wrong order. Your Lordship saved me. Because
Where?
I filed an application with insufficient materials. Therefore, your Lordship, upon hearing or upon looking into
So I gave you liberty to file with
Yes.
better particulars. After that, you could not succeed. Then there is no case, Mr. Bhattacharya.
No. After
After
that,
better particulars, you have not succeeded. Then you have
no,
not.
I say, Miller, that after this, I filed
What
this
is the
application.
impugned order? What is the impugned order?
The page 156 and 164. Kindly come to
What has been done by that?
Then,
What has been done by that order?
Miller, kindly see that order, Miller. The assessment of occupational charge in a
Assessment of occupational charge in the title appeal.
no.
In a title appeal.
Title appeal, Miller, kindly see what were my prayers.
Yes. What is the rate of occupation charges?
Rate of occupation charge, Miller, 80,000.
80,000. Where is the property, Mr. Bhattacharya?
In Girish Chandra, in this Chittaranjan Avenue.
Chittaranjan Avenue. 80,000 is.
And kindly see for a second the order passed by the Supreme Court. This matter is pending 149 to 154. 149 to 154.
All right, then, Mr. Bhattacharya, give them a copy.
We have given them. I have served.
Only Procedural fix the matter. Wendy's dot any day.
I have served.
Mr. Roy is out of season. Only Wendy's dot any day. As per convenience of the owner.
Kindly see, Miller, this 149 and more particularly paragraph 9. The matter is pending, and Miller, what was the direction, Miller, which I could find, which I could not show to my lords on the last occasion.
Yes. So according to you, you are not liable to pay anything.
No, I am liable to pay, Miller, that amount. It is a deposit before the Registrar General of this Honorable Court. In terms of the order of the Supreme Court.
What is all amounts to be deposited before the Learned Registrar General?
Miller, kindly see this. I say, Miller, kindly see page 149.
No, you tell me. I take your words.
This amount to be paid. I'm reading for my lords, Miller. The petitioner and other tenants of the building, including the Bank of Rajasthan, will not pay.
Where you are reading?
Miller, at page 9, at page 152, para 9. The petitioner and other tenants of the building, including the Bank of Rajasthan, will not pay any rent to the respondent, who is the landlord, but will deposit the same with the registered appellate side of the High Court, Calcutta, from month to month on or before 10 days.
Oh, your difficulty is in paying to them.
That's my only thing, nothing more.
So you deposit before the Registrar General at this rate?
Yes.
At this rate, that's your only difficulty.
No, I say, Miller, that the rate which they say, which they claim, this rate is required.
Now you are on the rate. First you said our difficulty in paying to them because the Supreme Court has said that it is to be deposited before the Registrar General.
No, I say.
Now you say rate is also a difficulty.
Now, that is also, Miller.
So let me first adjudicate the rate.
No, kindly.
Then I will come to the who will get that.
Without prejudice to my rights and contentions, if my clients will not pay, Miller, just 1 second, I am taking the instruction.
What is the, Mr. Bhattacharya, what is the proceeding for which the landlord was deprived of the rent? What have you done? You have paid anything for liquidating any property taxes or so? Why?
No,
why this was directed to be deposited?
Matter is pending before the Supreme Court.
I appreciate that. Why?
Mr.
Bhattacharya, I am asking you, why the Supreme Court has directed not to be paid to the landlord to be deposited before the Registrar General?
Unauthorized construction.
Unauthorized construction?
Yes.
Of what?
Miller, of some floors of the structure.
You are in occupation of that unauthorized construction?
Miller, that I am just...
Please vacate, Mr. Bhattacharya.
Yes.
Vacate.
No, I say, my lord,
Unauthorized construction, how can you?
no, kindly see, my lord, that since this matter is pending, kindly direct me, my lord, to pay the amount.
Did not. Demolished.
No,
Unauthorized, you said.
no, I say, my lord, this must be.
Unauthorized, they are not entitled to, accepted.
I
But
say,
can you enjoy an unauthorized construction?
my lord, that has to be decided in this matter.
Yourself is saying.
No, I am saying, my lord, kindly then look into the order, my lord. I appeal to my lords.
Is and what has been done? Unless you pay these occupation charges, what will be done?
Because they are proceeding with the execution.
Yes.
Now, my lord, at this stage, if your lordship directs me, I can pay, my lord, before the particular, my lord, Registrar General of this court.
Execution is at what stage, Mr. Vadajaji?
I find, my lord.
Verification stage.
No, my lord, I say, my lord, I
Bailiff has
found
been appointed.
page 165. Kindly see 165.
So it's long way to
Verification
go.
stage.
Let the execution proceed till the issuance of writ to the bailiff.
My lord,
That
then
stage, no
I
difficulty.
suffer the consequences. Kindly consider, my lord, that your lordship is balancing both the sides.
Yes, yes.
Kindly, my lord, kindly look into the condition that, my lord, my
Like when when this matter is taken up for hearing,
and only one thing, my lord, kindly see.
July date fixed for passing order.
Date fixed for passing order is at page 171.
what is the date?
14 July.
14 July.
For 208 application was changed.
What will happen?
So kindly give.
What order will be passed?
208 will be allowed.
208.
Yeah, for 2/14/7/2025 for order in respect of the petition under section 208.
11th করে দিন 11th করে দিন I'm coming after 5 minutes.
Matter number 9.
May it please your lordship, my lord. I beg to appear on behalf of the preemptive opposite party.
Yes.
Preemptive. I am petitioner in the instant divisional application, my lord. I am challenging the order number 19 and order number 2. My lord, I am covered by the Barashat Eye Hospital case, my lord. In my humble submission, my lord, subject to my lord's solemn observation. The property actual valuation was 2,62,000. My lord, the preemptor assessed the valuation as 1,74,000.
Where is your application dated 3rd of July? You have challenged 2 orders. Where is the first order?
I have challenged 2 orders. I have challenged 2 orders, my lord.
One is order dated 29th of March 2025.
My lord, and another 29th of June 2021.
29th of June 2021. How can we challenge that now, Mr. Banerjee?
Because my lord, that in that order, the learned trial court came in the aid of the petitioner to cure the defects of the inherent of the application of the preemption application, and that was passed when no copy was served upon me. After, if your lordship kindly comes to the facts, my lord, the date of registration of the deed is 3rd March 2021. Your lordship will kindly see that at page 12, para 5. If your lordship kindly comes.
Where is the preemption application?
Preemption application is at page
preemption on the ground of?
On the ground of vicinage, my lord.
On the ground of vicinage. Yes.
Page 9, my lord. Preemption application was filed on 22nd June 2021.
22nd of June 2021.
22nd of June 2021.
Yes.
Now, if your lordship kindly comes to order number 1.
22nd of June 2021.
2021, my lord.
When the transfer took place?
My lord, transfer date of registration is 3rd March 2021. 3rd March 2021.
3rd of March 2021 is the impugned deed.
Impugned deed, my lord.
Date of transfer.
Date of transfer. That is within time.
And the application was filed on 22nd of June.
22nd of June 2021.
And the
full statutory payment was not made.
Suit filed. And when the order was passed, first order was passed.
My lord, kindly come to the first order, my lord.
When it was passed?
I am coming, my lord.
By that he was directed to deposit.
No, my lord. Not on that. On order number 2.
Yes.
First order is 22nd June 2021.
No. 29th of June he was directed to deposit.
To deposit.
Yes, that is on 29th of June.
Of 29th of June.
Yes, please give me a minute.
Therefore, the petitioner is likely to deposit the rest of the amount remaining.
According to you, that could not have been done.
Could not have been done without
Barasat Eye Hospital.
Eye Hospital, the court had no power, my lord. The landed court had no power. And secondly, even if it is the
why, Mr. Banerjee?
The amount,
why?
My lord, kindly, my lord, second.
Mr. Banerjee, please kindly come to section 8. Please kindly come to section 8.
My lord, just 1 minute, my lord. My lord, if your lordship kindly comes to directed to deposit on 29th June 2021.
Yes.
Now, if your lordship kindly comes to
when the amount was deposited.
I filed my lord 2 applications, 1 maintainability.
When the amount was deposited.
My lord, that is the main point, my lord.
Yes.
Page 37, page 39.
Yes.
Page 39, your lordship kindly comes. Page 39.
When the amount is deposited.
My lord, paragraph 3, my lord. Page 39, your lordship kindly comes.
Give
That
the
the
date.
circuit court did not register the suit due to short deposit, and according to the petitioner
Mr.
deposited the rate.
Banerjee, whether the
13
amount,
July, 13 July, it is mentioned here. 13 July. 13 July 2021, on the basis of the order dated 20th June 2021, after the statutory period. It is in their objection made on affidavit. The deficit amount was deposited after the statutory period, which cannot be done in my humble submission. Paragraph 34 and 35 of the Barashat Eye Hospital case. The period cannot be extended. In both objections to the application for maintainability and objection for application for recall, in both the objections, he have categorically stated on oath that it was deposited after the statutory period, which cannot be extended.
there is substance.
Next, item number 10.
10, my lord, I beg to appear on behalf of the petitioner. My lord,
Yes,
would it be my lord's kind pleasure to take it up tomorrow, if possible? My lord, I'll tell your lordship what the problem is. The problem is, my lord, that section 10 application has been rejected. My lord, there is a partition suit, which is an earlier suit, and there is a probate proceeding.
yes,
Now, my lord, in the probate proceeding, my lord, whatever happens, the partition suit is an earlier suit, and there are disputes, my lord, with respect to title.
yes,
So, if my lord, the earlier suit, my lord, continues, my lord, and the next suit, my lord, would have to be stayed. My lord, I was also wondering, also, my lord, I'll be very candid before your lordship. I was thinking whether, my lord, both the suits can be tried together. But allows me just today's time. I'll my lord, take all
what
instructions
is
and
the
my lord,
status of both the proceedings?
more or less at the same
Same
stage.
court.
Same court.
Lord, the probate proceeding, my lord, for my lord, settlement of issues, my lord, I find. And so far as
Issues, and here this is for receiver, and then thereafter. I don't think the stages would be, my lord, anything different.
here, my lord,
Not,
my lord, the declaration of share, my lord, with regard to the partition suit, my lord, is depending on, my lord, the probate proceeding.
yes.
Now, my
So
lord,
what do you suggest? Partition suit should be stayed
no,
till
my
the
lord,
disposal of the probate proceedings.
my lord, it should be, my lord.
Should be stayed.
My lord, his prayer is otherwise.
Show me the decision.
His prayer is otherwise.
That is the different thing. What's the almost Supreme Court has said? There are two line of decisions on this.
Yes, my lord, one, my lord, is with regard to, my lord, both the suit, my lord, should run analogously, and my lord, final conclusion, my lord.
And the other one,
Other one is, my lord, with regard to, my lord, the partition proceeding, my lord, there is a judgment, my lord.
yes. I'm asking you, what is the judgment?
My lord, may I come back with those two judgments, my lord?
Mr. Chakravarti, you are doing these matters every day.
Your lordships, my lord, since my lord, the section 10
Well settled, Mr.
Your lordship
Chakraborty.
kindly consider, my lord, they have not.
There are two, as you have rightly said, in one volume, there are two decisions. Or in two
My lord,
successive volumes, the subsequent decision has been reported in the earlier volume, and the earlier decision has been reported in the subsequent volume in the same year. That's what you have said, clubbing of those two proceedings. And the other is also,
my lord, let my learned senior friend come back tomorrow, my lord, I'll come back, my lord, with the judgments.
you are the plaintiff in the partition suit.
No, my lord, they are the plaintiff, my lord, I have been added party there, my lord, I am the adapted, my lord.
You are the defendant in the partition suit.
Yes, subsequently added.
But you have filed the probate proceedings.
I have filed the
You are the propounder there.
Yes.
Yes. So according to you, the partition should be stayed.
Lord, their prayer is,
What
Lord,
their prayer?
Their prayer is, Lord, rather, Lord, just opposite, Lord, to this. Their
Probate
prayer
should be
is
stayed.
probate should be stayed.
That Mr. Chatterjee, I think, will not press now. Yes, Mr. Chatterjee.
I
press to
opened
that.
my mind. I opened my mind a little bit,
Yes.
Lord.
Mr. Chatterjee is not pressing that.
Now, do not say that I'm not pressing at the moment, but I opened my mind before your lordship, Lord.
Yes, yes. His mind for analogous hearing.
Let it be, Lord, run, Lord, analogously.
Yes, Mr. Chatterjee, I am directing both these two proceedings to be, is it in the same court?
No, Lord, the probate.
Not on the same court. Lord, just keeps it tomorrow as to be mentioned.
The district delegate Asansol, Lord, the probate proceeding.
No,
Lord, kindly bears with you.
Not a contentious cause.
Yes, yes.
Yes,
All
yes.
District delegate.
Lord, now
Lord,
just Lord.
So after contentious, where it is now?
additional district judge.
Lord,
Lord,
so before the
Lord, keeps it tomorrow as to be mentioned, Lord. I'll give your lordship the details. To be mentioned tomorrow, Lord, in the morning. I'll come and tell your lordship.
Mr. Chatterjee, fixing a date, another date for one matter is a very difficult thing.
To be mentioned just for the facts, nothing more than that. Is a difficulty today.
You suggest two parties there, hearing will be there. So
tomorrow in the morning.
What
Tomorrow in the morning. Tomorrow in the morning.
Yes, learned additional district judge first court at Asansol.
So that is the probate.
Probate.
And the partition?
Partition is senior division.
Senior division.
It is recorded in the order.
There's just one problem in that, Lord, because if the courts are different and their powers are a little different as well.
What are the powers? What are the different powers of the court?
Not the powers as such, Lord, but their powers to try pecuniarily.
Yes, yes.
That is the only.
Mr. Chatterjee, if it is transferred,
yes. I bow down,
there
Lord.
cannot be any difficulty with regard
No
to
difficulty. Just give me one. Just give me a day's accommodation. I'll take instruction. I'll come back tomorrow in the morning. Kindly keeps it tomorrow in the morning.
Two things. What are the stages of both the suits?
Absolutely.
Which is the, please prepare a list of dates.
My lord, we'll do that.
What is the stages of
the suits in the peremptory hearing stage?
And those decisions, one line of decisions which you have said.
I'll give it to you.
Decisions, the partition suit to proceed up to what stage? So even if it is not another, there is another line.
There is.
Both the suit will concurrently, it can
That
be
is one thing. And if you say the stages are not the same, there is also another.
Lord, I am not aggrieved. Lord, they are aggrieved with Lord, the stay refusal with regard to my probate proceeding. That cannot.
I Lord, in a way, mellowed down my arguments with respect to that.
Hard message. Yes, Mr. Ghosh.
No, this is with regard to visitation right. And my lord, in respect of a child.
Who are you?
I am for the father.
Who is for the mother? It's ex parte.
Ex parte.
No caveat.
No caveat.
What is the order impugned?
My lord, an application was filed, my lord, before the trial court for permission to keep the child, my lord, with me during the summer vacation of the school. Child, my lord, is a
That was rejected.
in effect rejected. My lord,
You are challenging that order.
No, I am telling you, my lord, this is in respect of a child, my lord, who is suffering from autism. And my lord, the medical science says that both the father and mother should take part, my lord, in the development of the child. That is and that is what has not been granted to me.
Mr. Ghosh, I am asking you, is it practically possible?
My lord?
Considering the now the present, I must say that position of the parties where they are now, is it possible that both will participate for the development or cooperate with the development of the child? How can that be done?
My lord, your lordship will see, my lord, even the visitation order which was
I appreciate that, but you have said, yes, it should be done. But I am asking you, how that can be done?
What I am submitting before your lordship is this. My lord, I am serving notice upon him, the wife. Now kindly take it up, my lord.
What was your prayer in the application?
Application, my lord, that is actually, my lord, it is against an order where the visitation right was rejected with regard to during the
Summer vacation. That has lost its force now.
But even apart from that, my lord, learned judge has made certain alteration in the order itself.
Show me that. Alteration meaning thereby modified some earlier order? No.
Yes. And my lord, if
Where is
this
that?
order stands, my lord,
yes.
the parties will go back to the earlier interim order which was passed by the learned district judge, which permits, my lord, only 2 days in a month visitation. And I have stated, my lord, in my application.
What is the impugned order? 7th of April 2025.
My lord, 2nd of June.
2nd of June.
Yes.
That is after the summer vacation. Summer vacation was till 2nd of June.
Well, summer vacation was up to 13th.
13th of June.
Yes. Well, kindly turn to that order, my lord, page 186. Thank you.
No, which portion, Mr. Ghosh, you are saying that it is modifying that?
Well, that is with regard to.
Because considering the summer vacation,
yes,
you are allowed 4 additional days.
No, my lord, first, my lord, one thing. First, your lordship kindly turn to page 188.
188.
Yes, my prayer was rejected at that time. Page 188, my lord, the line stating, my lord, in such circumstances towards.
Yes, considering the special health.
Special health of the condition of the child, I find at this stage the prayer as made by the petitioner cannot be allowed in its entirety.
What was your prayer?
Prayer was, my lord, for keeping the child, my lord.
During the portion of the part of the summer vacation. Yes, sir, that might be difficult. Mr. Ghosh, what is the age of the child now? Male child or a female child?
About 5 years.
Male child or a female child?
Male.
About 5 years.
And my lord, we have stated.
What was the age of the child when you both of you are living apart, staying apart? What was the age of the child at that point of time? When you started to live apart?
2.5 years.
It's difficult to keep.
No, my lord, I shall
that. But for the present, now what do you want now?
My lord, I want this. Kindly, I am serving notice upon the other side. Let them come.
Yes.
And let it be your lordship kindly.
No, what do you want? I am asking you.
My lord,
what is your prayer? What will be your prayer?
That's some, my lord, substantial time should be given to the
How much time? When? He is studying in a school.
studying in the school.
In
And
the
my lord,
school.
I've stated in my affidavit, in the petition, that he remains
What
quite.
is the present arrangement now?
My lord, kindly see that order.
Page 188.
186,
Yes.
third paragraph from the bottom.
186, third paragraph, yes.
By way of an ad interim order dated such and such, learned judge.
Visitation shall be allowed by way of for a period of 2 hours each on every second and fourth Sundays.
That is the original order. That is, my lord, 2 hours. And my lord, the.
And Mr. Ghosh is the South City Mall.
No,
Place where this type of child should go.
No,
the
my lord,
visitation
that is
should be
the order given by the.
But you have accepted
judge.
that. You have not challenged that. Yes, considering the health of the child, which
Yes.
you have said,
Yes.
is it the best place for the child?
Well, my client has got no other option but to accept it. Even then, my lord, they.
What is the better option which you can suggest? Please consider this, considering the special health which you have said.
Yes.
What should be the best place? I don't think, yes, in other cases, South City Mall, there are some zones, yes.
Also, my lord, I also think, my lord,
Since you have
City
said that,
Mall is not the place.
considering the special health,
Yes.
whether that should be an ideal place for
Yes.
for this type of a child. Please consider that, because after all, it's the welfare of the child that you have to consider. It's not that you want some days more, some days
Just
less.
a minute. My lord, amongst themselves, by discussing amongst themselves, my lord, sometimes they not in the mall, but in other places also it has been done. But what I feel, my lord, that let the wife come. My lord, kindly spend some time, my lord, with them. And I shall show, my lord, what is the medical science says with regard to this development of this child.
I appreciate, but
I have got the well, because both my lord,
any
parents,
divorce proceeding pending between the parties.
yes, judicial separation. Judicial restitution. Restitution of conjugal rights filed by my client.
Mr. Ghosh, can it not be settled? Considering the health of your child, both
Yes.
of you cannot settle
Yes,
amongst
that is
yourself.
what I want, my lord. Kindly, I am serving notice, my lord. Kindly spend some time, my lord, with the child and as well as the two parents.
I think you should be the best person
I will
to
be there.
consider
I will
that.
be there, my lord. I will be there.
Since you are here, please consider what will be best for the child.
I shall think
And
over
please
it, my lord.
advise your client accordingly. Since you are here, I am telling this because yes, child's welfare is paramount.
Yes.
And since you have said that special health of the child.
That also, my lord, in respect of all other cases.
Yes, yes.
But
That is
here,
why I am
my lord,
saying.
is a
Here is,
special.
yes.
Yes.
Considering the
Yes,
health.
my lord, just 1 minute. Put some
Number 12.
The capital action.
Yes, Mr. Rai. Yes, what is saying?
He has now become a big boss.
Not now.
But along with the child.
No. I have not directed.
Otherwise, my lord, your lordship won't be able to judge, my lord.
Let me first hear.
Attachment, whether he is attached to.
Mr. Ghosh, let me first hear them, then I can fix. Let the opposite party first. I have not directed the child to be brought because I have to understand what is the present position of the child. Then I will consider. If that is to be done, that may be on 2nd of August, 2025.
খোলা ওটা খোলা বলেছে না ছুটি পেলাম ওই জন্য আমাকে বেকার
For the welfare of the child, Mr. Ghosh.
He is my grandson. So my nephew. But he has become criminal. Practicing in the criminal.
Why? You could not bring him here in this field.
His father came to me with I told him what he wants. The civil side of the criminal side, my nephew is there. So the chances of
But
that is
yes, that's the choice of a.
but he is doing well in that.
But you should ask him to do some cases in this field also. Wish you all the best. Yes, Mr. Rai.
My defendant is the petitioner for your lordship. The suit for eviction based on title.
Suit for eviction based on title. Yes.
Does it file suit decreed? Against that, an appeal has been
decreed.
Suit decreed.
Yes.
An appeal has been preferred. In such appeal, it appears that subsequently a suit was filed for specific performance of contract on by Parulwala against the degree holder or the opposite party herein. I want to bring that fact in my written statement. The title based on which the suit has been filed is subject matter adjudication in the other suit.
So, claiming that you are the owner of a property, you filed a suit for eviction. Against he filed.
He filed.
He filed a suit for eviction against you. Now that suit has been decreed. In the appellates, in the first appeal, so in the meantime, you have filed a suit for specific performance.
No. Another person who was there, who filed a suit for
against him.
Against him.
Yes.
I want to bring that fact because it's a subsequent event. Suit was decreed on.
How that is relevant, Mr. Rai, in this suit?
So whether the title remains with that person if the suit is decreed or not. If the title remains with the person who filed a suit for eviction against me.
What you will do by that? Can you prove that? What you have a hand in that suit?
No,
so then the appeal is to be stayed. Thank you. Anything more, Mr. Rai? Anything more?
This is the amendment I sought for.
Any decision you want to rely upon?
What is so? Whether it's a subsequent event or not?
Yes, a subsequent event.
Now,
all subsequent events are to be incorporated.
My lord, whether amendment of reinstatement.
Show me your
yes
amendment. Show me your original written statement and show me your application for amendment.
Kindly turn to one thing, my lord. The prayer made in the plaint itself, page 15.
Page
15.
Page 15 is the yes.
So this is the recovery of khas position.
Yes.
Now page 37.
Page 37 is the decree.
Decree. So declaration given which has not been prayed for. Be as it may, I am not on that also.
Then my lord, kindly turn to my application, page 43.
Yes. No, show me your written statement first. That's relevant, not the degree. Show me your written statement.
Page 19.
19. Yes. Show me your specific defense case. It starts from which paragraph?
If your lordship can turn to paragraph 7.
Paragraph 7 or paragraph 5?
Paragraph 5 and 7.
What is title suit number 57 of 2000?
Partition suit. What happened? This is
mother of the defendant.
Yes. The property already
claiming to be a co-sharer.
Co-share in that sense also.
Because and that was dismissed.
That was initially decreed. They went up to the appeal. This honorable court also maintained that degree. Then the Supreme Court says whether the life interest can be converted into a absolutary in terms of.
Where is your application for amendment?
Section 14. 43. Schedule, page 45. Relevant paragraph 3 E and F.
3
E and F.
Because A and B were stated in that.
There is nothing.
So you are on E and F only.
সুটের এটা কোথায়? সুটের 3S. Page 51. And page 51, 3S. Yes.
Yes.
Yes, page 51.
It's longer than the original written statement.
4th page original, it is 11th page millet.
Yes, yes.
And the reason
who is Parul Shashmal?
Yes. This is the person who was residing at that relevant point of time with the testator. 3E. That is why I lost it on 3E.
Yes. And what is the reasoning given by the learned judge of the appellate court?
This is the last page your lordship will find. So far, the amendments sought to be incorporated from the top your lordship will find. Last but one page. Of the
last but one page.
Yes.
It's in addition. Yes.
So far, as the amendment from the top your lordship will find.
Kindly
last
consider
but one page.
From page 5.
Last
consider
but
this
one
submission.
page. That is from page 5.
Page
or
5,
from
consider
page
this submission. Yes.
Mr. Rai, you can start from the previous page. At the very outset.
It is also by way of subject to the amendment application, the applicant merely reiterated the demolition property upon them narrating the details of the will executed by the original owner. This is already there, but that's why I don't know. That is why the next page from the top.
Kindly see the last paragraph of millet page 5 from that.
So here's some argument, my lord. Then he requires consideration.
Yes, yes.
No.
I will consider his submission also.
Then the independent proceedings with separate cause of action availed by the plaintiffs in those cases. These two suits apparently do not have any connection between themselves. Are not relevant in this case, fails to understand how the alleged agreement for sale for specific promises of contract or outcome of the said proceedings can at all affect the merit of either of the parties to these proceedings. I'm on there.
Anything, Mr. Rai? Anything, any decision you are trying to rely upon?
My lord is.
Yes, yes, yes.
Milord, I rely on Milord the judgment, Milord passed by the Milord the order passed by the learned.
Not anything more.
Milord, there are no connection whatsoever between the Milord the two suits. Now,
LIC's judgment you have not brought.
Which was it?
LIC's judgment you have not brought, Mr. Rai.
আচ্ছা অস্ত্র নিয়ে বসে গেছে কি করবে
I mean, the suit was decreed in 2016. The application was filed in 2025. Milord, only ground which has been given Milord by the Milord, my learned friends, client, my senior friends, clients, Milord, is that a new advocate has been engaged. Milord, order 6 to 17.
That cannot be a ground.
Proviso, my lord, my lord, can you consider this a suit of 2017, suit decreed of 2016? How this proviso will apply for the purpose of incorporating the subsequent event?
The suit in my case, Milord, in decree 2016.
Yes, and this suit filed 2017. So how can
there will be no ending to a matter.
And the amendment of written statement is standing on different footings than
Yes, liberal, more liberal than plain. Anything more? I asked you whether you want to cite any decision, you said no.
And that was so confidence.
One is subsequent event has to be allowed.
And
proviso cannot be a part. Second, written statement more liberal than the plaintiff. Mr. Rai, these are the two things and this is necessary for the purpose of
because the suit based on title.
This application under Article
everything, my lord, I can be there on that side, my lord, tomorrow.
Yes, for the
Item
next
number
matter.
13, time for the petitioner.
Yes.
The suit under the West Bengal Premises Tenancy Act.
Yes, what happened? What is the impugned order?
The impugned order has been passed on 19th of May 2025 in respect to the application under section 7(2) of the West Bengal Premises Tenancy Act.
Yes, what
My
happened?
lord, the only ground, my lord, which we have taken in 7(2) of application is that there is no landlord-tenant relationship between the opposite party and the petitioner. For the reason being is that the landlord is a trust, my lord. The rent receipt was being issued in the name of estate of late Saroj Kumar Sengupta. If my lord be kind enough to take page number 25.
Don't pay. There is no relationship.
No, my lord.
Suit will be dismissed.
No, contention was that
it will be dismissed.
Contention was, my lord, as per order.
You will not be affected.
My lord, I have been, my lord, when the summon was received, my lord, I have taken out my application under section 7(1). Same point was taken by me, and there was liberty was granted to me.
There is no landlord-tenant relationship. That's
Without
the basis of a suit for eviction. Suit will be dismissed.
That's correct, my lord. Without
You
prejudice.
did not pay anything.
Without prejudice, I have been making payment, my lord, in terms of the court's order passed on 13th of December 2000.
Now what do you want? If you are making payment, what do you want now?
My lord, I have taken a point in my 7(2) application to adjudicate the relationship of landlord-tenant relationship. This plea was taken in terms of order 31, rule 1 of the Code of Civil Procedure, my lord. If my lord will kindly take up the plaint, my lord, at page number 13. My lord will find neither in the cause title, my lord, there is any relationship with the trust, neither with the body of the plaint, my lord. There is no relationship has been stated as to how the plaintiff is related with the trust, my lord. And there is a perverse finding, my lord, in the order holding that this particular plaintiff is the trustee, my lord. My lord, even then, my lord, if my lord may allow me to place. So there was a caveat, my lord, I have served, my lord.
Who issued the rent receipt?
Rent receipt was issued by estate of late Saroj Kumar Sengupta, page 25.
Rent receipt was issued by rent receipt. I'm asking you.
If my lord will
show me the rent receipt.
Yes, my lord.
Who signed on the rent receipt?
Page 30, my lord.
Yes. 30.
Yes, my lord. It was signed by the plaintiff, my lord. As trustee, my lord. So the contention which I have taken, my lord, is as per order 31, rule 1. If my lord will kindly permit me.
Have you seen the definition of the landlord?
My lord, yes, my lord.
Does it not fall within the definition of landlord? West Bengal Premises Tenancy Act hota hai, deal.
My lord, may I?
West Bengal Premises Tenancy Act.
To see, my lord.
Yes, yes.
My lord, this issue, my lord, has also cropped up before the honorable other high courts, my lord, which I will be placing reliance upon, my lord, before the honorable Delhi High Court, as also, my lord, before the honorable Madras High Court, my lord, wherein also, my lord,
this is only a tentative finding.
Landlord.
So that will be an issue in the suit. Thrash it out there. Thrash it out there. Landlord includes any person is receiving or is entitled to receive.
My lord, rent receipt has been issued in the name of the trust. If my lord will also consider order 31, rule 1 of the Code of Civil Procedure, if my lord will kindly allow me to place.
Sir, this is the tentative finding, sir.
My lord, my lord.
So at the time of the issues, it will be decided.
There is also one error, my lord, in the plaint. If my lord will kindly see plaint, page 13.
Have you deposited this amount?
My lord, I have been depositing amount.
This amount you have been directed 5330.
Yes, my lord, I have been depositing since December 2019 onwards. And my lord, the rent receipts which have been the rent deposit challans, my lord, on the day when the matter has came up before the
deposit, this is a tentative finding that will be considered along.
My lord, if my lord will kind, there is one more issue, my lord. My lord, in the plaint, my lord, there is an statement that I have been defaulted in making payment of the rent since October 2018. My lord, in my 7(2) application, I have specifically stated, my lord, that I have made payment of October 2018.
From your 7(2).
My lord. My lord, first, I am showing, my lord, the contradictory statement made in the plaint.
Not comparative statement, show me your 7(2).
7(2), right?
Let me see what is the case made out.
Page number 24, my lord. My lord, paragraph number 2, my lord, at page number 25. The defendant denied that the plaintiff is the landlord of the defendant in respect of the suit property. The defendant states that the state of late Saroj Kumar Sengupta, a trust also known as Saroj Kumar Sengupta Trust, is the landlord of the defendant in respect of the suit property. My lord, with regard to the payment of rent, my lord, as stated in paragraph number 4, paragraph number 5, my lord. No, more categorically in paragraph number 5, my lord, that I also made payment of rent of October 2018. Thereafter, by cash, my lord, no rent receipts were issued. And this statement has been accepted in my rejoinder, my lord. To the written objection filed to this 7-2 application. And the learned court, my lord.
October you have paid.
October I have paid, my lord.
Where is the rent receipt?
My lord, rent receipt is that has been paid through check, my lord. I have annexed, my lord, the check as well as bank statement. And in the rejoinder also it is admitted that I have paid, my lord. Rejoinder issued by the landlord, my lord. My lord will kindly see page number 80, my lord. The check I have annexed, my lord, by which I have made payment, and also the bank statement. And it is also paid in the name of Saroj Kumar Sengupta.
And you have been directed to pay from October. So from November you have not paid.
No, from November 2018 to November 2019, the payment was made by cash, though rent receipt was not issued. From December 2019 to till date, I have been depositing in court, my lord. All challans I have annexed, my lord.
When the suit was filed?
One thing more, my lord.
When the suit was filed?
The suit was filed in 2019, my lord. Exact date, my lord. I have annexed the entire order sheet, my lord. My lord, kindly give me a moment.
So,
suit was filed, my lord, on 16th September 2019.
16th September 2019.
2019. I entered appearance on 13th December.
According to you, you have paid rents till which date? Till November 2019. From November 2018 to November 2019.
Till October.
So according to you, the dispute is with regard to October.
With regard to November 2018 till November 2019. October 2018 admitted.
Where is the admission? You have said that you have to deposit from October 2018.
That is an incorrect finding, man, with deepest of respect.
That is what I am saying. That's the, according to you, an incorrect finding.
Incorrect finding.
And with regard from November 2018 to November 2019, show me the documents that you have paid.
That has been, I have stated in my 7-2 application, payment were made by cash, no receipt was.
You have to prove, sir.
That I will pay, my lord. That I will pay, but with regard to the court deposit, my lord, from December 2019, which the court had again asked me to deposit from December, my lord, that is an incorrect finding, my lord. I have been depositing in court. My lord, all challans I have annexed, my lord. If my lord will see.
Yes, sir. What do you say?
Page number.
Page 73. Written objection of the page 73. My written objection to the.
What do you say to this? After November 2019, according to him, he is depositing before the court.
Court deposit, but
so, but the court has not considered that.
I have admitted that October 2018 is paid. That is denied in my written objection. Page 73.
So he has said that he has paid by check, and that you have.
Page 73. Page 73. Paragraph 4. Last portion. The defendant never paid rents either by personally tender or by
paragraph
4.
The defendant never
paid rents either by personally tender or by remitting any check in favor of the plaintiff since
November 18.
And as such, it is absolutely false that the paid his rents for the period from November 18
till October 18. It is admitted.
No, my lord. Now paragraph 3. Over there is written the defendant is a defaulter in payment of his rent since October 2018.
Yes, you have said, where is the admission?
My lord, will see, defendant never paid rent. My lord, kind. Defendant never, defendant never paid rent, either personally tender or remitting any check in favor of the plaintiff since 2000.
Paragraph 3, he has stated October also not paid.
My lord, I have annexed the check also and also the bank statement. My lord, will kindly see the check and the bank statement which I have annexed with my written objection. Now the written objection is at page number 73, my lord.
Where is your bank statement?
My lord, I have annexed the bank statements.
Show me that.
My lord, kindly give me a moment. Page number 80, my lord.
80,
my lord. Check. My lord will find 2 checks, my lord. First question, my lord had asked who has issued the rent receipt and to whom I have made payment. Payment were also made to the trust, Saroj Kumar Sengupta Trust. 6 September 2018, 4th October 2018, my lord, for the month of October. Check 4th October 2018. Next line, next page is the bank statement, my lord. Page number 81.
Page number 81.
My lord.
So these are the two checks for.
One is for September 2018. September they are admitting. In plain they have stated I have not made payment of October 2018. In written objection I have stated that the payment was made through check.
And you have a better copy. You have given those marking.
Yes,
it cannot be read.
My lord, where is it mentioned that it has been paid for the month of October 2018?
If my lord will,
have you received this check? Have you received this bank account shows you have received that check? Yes, sir. Do you have a better copy?
My lord, right now, my lord. No, right now, my lord, I'm not carrying, my lord. I'm tendering my unconditional apology, my lord. My lord, whereas paragraph 4 of their, my lord, objection clearly says that since November 2018, they have not been paid.
No, here it says September and October both have been encashed.
Yes, my lord.
This is the check issued in your name.
In the name of Saroj Kumar Sengupta Trust, the landlord. My lord will also appreciate that.
What?
That the payments were made in the name of trust, not in the name of the plaintiff. Payments were made in the name of Saroj Kumar Sengupta Trust.
Yes, yes, that may be. But earlier entry receipts are also there. For that, yes, that's your check, something you have written. That does not bind them. Yes, what is the
My lord,
submission
my
with regard to this?
specific case-
October, this check has been encashed.
My lord, I need some instruction from this. My lord, the instruction is just received up to October. Up to October is.
So up to October, so this is the wrong finding. So from November, and what is with regard to the after appearance, he says that he has regularly deposited.
From
that has also not been considered.
Yes, my lord. From December 2019 onwards, all rent receipts have been annexed from page number 42 to 72, my lord. Page 42 to 72, all rent challans are there.
There are challenges, but my instruction is that there's not, but.
And I've been depositing
Sir,
continuously.
please take instructions.
I'm taking
Or I have to remand back. So
My
if
lord,
you-
I-
according to you, yes,
No, there are
after that,
challenges. Admittedly, there
and
are
from November 2018 to November 2019, he also says nothing. So after that, from December 2019, according to him.
To till date, I have been making court deposits, my lord.
Ashu.
My lord, may I be allowed to see instructions? In respect of the same suit premises.
So there is a
another
difference, facts are different, my
All
lord.
right, let me.
Facts are.
Yes, next.
14. Item number
Facts.
14.
Facts.
I am
Yes.
appearing for the petitioner, my lord. In this matter, we are praying for an expeditious disposal of the application. Application was filed for declaration that the defendant number 1 is a concubine of my deceased father, and the family pension should be granted to a sister physically challenged person, my lord.
This application under Article 227 of the Constitution of India. Yes, 15. Yes.
My lord,
My
apart
lord,
from the point, my lord, which I have taken in item
My lord,
number
I have filed the wakalat number today.
Yes.
The same plaintiff.
What is the dispute here?
dispute, my lord.
Copy has not been served. I pray for service of
My lord,
copy.
may I hand over a copy?
All right. The petitioner is there. When the next.
Same facts, but as of
what is the next date fixed?
no, next date fixed, my lord. My lord, thank you. My lord, in August.
August. So I have
Same lord, limited same.
August.
My lord,
I have kept
purpose
it after.
finding regarding to 2G,
Let
my
me
lord.
see. Let me see. In the meantime,
Lordship,
please take instructions
Lordship,
with
the
regard to that.
application
And
and
Yes, yes.
section
I have
20,
said after 2 weeks, it will appear under the hearing motion. Yes.
application for divorce under the Special Marriage Act, section 27 is pending. Wife filed an application under section 36. Interim maintenance allowed, but so before the going to the interim order, Lordship, kindly come my affidavit of assets, page 41.
15,000 has been directed.
No, 30,000.
No. By of May, 15,000.
15,000 each. Son, my son, age of the son is 4 years. For the same reason, also 15,000 has been granted, and 15,000 for the wife. Whereas my income is 90,000. Now, also regularly I am paying 8,000 per month under the scheme, which is beneficial to my daughter. Also, I am paying the each and every month also the installments of EMI of the house building loan, which was purchased at the request of my wife. Now, Lordship, after deducting all these expenses, amounts reduced to 17,000.
Amount reduced to
17,000.
Where?
Lordship, kindly come my explanation which I have given.
All right.
Kindly
come at 2 p.m. Yes. Call the next matter.
Matter number 17. 1 p.m. 1 p.m. matter, Lordship.
Yes.
My lord, the defendants in a suit for declaration and injunction is before your lordship. Lordship, the stage is evidence. DW was going on. By the impugned order, DW was closed, and tomorrow is date fixed for argument. Lord, some earlier orders I have also annexed as page 20 onwards, my lord.
Why have you paid for time on the last occasion? Rightly rejected. It's not your right that you will pay for adjournment and this will go on.
No, my lord.
What is the ground on which you pay time?
My lord, the mistake in diary, my lord. In
Mistake
place
in
of
diary. But you could appear, you could pray for time.
Lord,
So that cannot be a ground. Mistake in diary means you could not appear. You appeared and paid for time.
24th, which was fixed for evidence.
Produce the diary. What was the mistake?
Lord, kindly grant me liberty. I shall produce the original diary, my lord. And it was produced before the learned judge also, as per instruction. But the client was residing at Montesor. He could not be brought, my lord.
By the order impugned the
I have received instruction to appear on behalf of the opposite party number 1.
My lord, I am praying for a short passover, my lord. Senior is on another court, my lord.
What is this matter?
There was enter unauthorized construction. There is a direction passed by the this honorable court contempt.
Come at 2 p.m. Yes, call the 1 p.m. fixed matter.
Order number 6.
Yes, Mr. Mukherjee. What is your instruction?
I have taken the instruction, my lord. In my objection, I have stated everything. Kindly permit me to file an application in the court below. And my lord, if I file, my court below will consider the same, my lord. But this is
the application you will file?
But for because my submission.
Say me, what is the application?
But my submission has not been recorded and
for review of that order.
On instruction, my lord.
I'm recording your submission. Mr. Mukherjee, I have to rely upon the statements of the learned advocate.
No, which I argued before, Lordship, everything has been stated in Lordship. There is no reflection in the order.
Mr. Mukherjee, learned advocate, now this application Say to consider and dispose of the same
Expeditiously.
in accordance with law as expeditious. One word or two word?
One.
Thank you.
Item number 18. I was for the opposite party number.
না ওটা পাসওয়ার্ড হয়েছে দুটো সময় নেবে
Oh, yes. Deeply appreciated.
হ্যাঁ ওটা তো ফেরত দাও। ওই অবজেকশনটা ফেরত দিতে হবে
Item number 1. I appear for the state.
Yes, Mr. Banerjee.
But I'm so grateful, my Lord, on that day, my Lord, your Lordship has accommodated me. And I have come with, my Lord, proper instructions and documents.
Yes.
And if your Lordship kindly permit me, my Lord, original journal diary book also, my Lord, with me. I have brought.
So I've got the journal diary book original.
Original and Xerox part. I have annexed in the report.
Yes, this is the fresh report.
Total report, my Lord. From
So on the last occasion, you have filed a report.
last occasion, that day, my Lord, I have not filed.
Yes. Yes, yes. Report was filed. Where is Mr. Chatterjee?
Sir?
Mr. Lilotpal Chatterjee?
He has not come.
He has not come.
I have not seen. No, he has not come here. But whether he has come.
Yes.
Let you kindly go through the report, Lord. May I read, Lord?
So let me.
Yes. Joseph, Lord, may I hand over a copy of the report to both sides?
Yes, let me see first.
धीरे धीरे जोसेफ बोल देना देगा ऐसे जल्दी से खोला आज पढ़ते वक्त कॉन्फिडेंशियल रिपोर्ट ना আইটেম নাম্বার কত এটা আইটেম নাম্বার কত আপনি জুনিয়র ছিল দেখো তো স্টেটের লাস্টে এবার দেখো সব সেটাই কি করেছি
Yes. Yes, Mr. Banerjee.
My lord. Therefore, my lord, the allegations and or accusations which have been made by the, my lord, the petitioner against the police, that they have forcibly hand over the possession.
Now,
that
Mr.
is not.
Let us not go into that.
And that is not correct. May I tell you?
All right, I will.
That is not correct because if your lordship kindly see the journal diary entry.
Answer these questions. My lord. When you went to the site on 1st of July 2025.
1st of
July 2025.
1st of July.
Yes.
Your lordship.
You went to the shop.
Yes.
On 1st of July 2025.
Your lordship kindly come
to comply, Mr. Banerjee, please hear me.
My
Otherwise, you will not be able to answer my queries.
My lord.
On 1st of July, on 30th of June, the opposite party made a request to you, a letter requesting you to see that the order passed by the trial court is complied. So on 1st of July, you went to the spot. What did you find when you went to the spot?
Yeah, that is.
Please give me the GD entry book.
Yeah, GD entry book. 1st July, GD out and in.
Please find it out. 1st of July 2025. Yes. What did you see then?
No, 1st July দাঁড়াও এদিকে আসুন তো মানে কাইন্ডলি গিভ দ্যাট
20 নম্বর স্যার
হ্যাঁ
জিডি নাম্বার
20
হ্যাঁ এটা স্যার আউট
এটা আউট আর ইনটা কোনটা
30 স্যার
এটা জানতে চাইছি
30 স্যার
30 29 30 Lord, this page, Lord, this is GT out.
I'm asking you.
Oh, GT out and yes, everything.
What you found when you reached? I'm asking you. When you reached
May
1st of July.
But that has been written in the GT. SI Sanjoy Mahata with others office and return to the PS.
Mr. Banerjee will rely on the report or the GD entry book entry.
No, the GD, I mentioned.
So you will not rely upon this.
No. I mentioned. I mentioned in the report.
All right.
And regarding the dispute of Tultul Bhandar shop, after arising at the shop, the officer found that Mohibul Mullah and Halim Mullah both are in the shop with them.
So you
Main-
found both of them inside the shop
Yes,
room.
kindly allow me. Yes, that's right.
Yes.
Means and trying to make shares. The police are
trying to make
shares. ওদের নিজেদের মধ্যে হ্যাঁ? Oh, make chaos. এটা ভালো করে লিখে
chaos.
Chaos. The police এটা কি লিখেছেন? তো কথা পড়া যাচ্ছে না। Approach to obey learned court's order and maintain peace.
But Halim
But
Mullah
Halim
and
Mullah and his men at first did not pay any heed. After several times so from police Halim Mullah and this so and agent left the place, noted in CD for so.
So when you went, you found both persons were inside the shop room.
Inside the shop and
Now, Mr. Banerjee, let us take a hypothetical case, not this case. Let us take a hypothetical case. Trial court passed an evidentiary order of injunction restraining B from dispossessing or not to disturb the peaceful possession of A in respect of a room. Now, on the next day, let us assume
we have to learn.
that on today we are on 7th. Let us assume that on 5th, this evidentiary order of injunction was passed. And on 7th, an application has been filed under 151. Look, the B is now disturbing my possession. That application has been allowed on 7th. You have been directed to implement that order. You visited the locale on 8th and you found A and B both inside the shop room. What you will do? What you will do? I am asking you. What will be your duty?
Our duty to maintain the peace and tranquility. We have said so in the report. We have not handed over any possession to anybody.
I'm asking you, what will be your duty?
Duty, we have requested. We requested the my management clients kindly obey the order. This is the order. Thereafter, we have left the place to maintain the peace and tranquility. We have not.
All right. Thank you. Now you come to your report.
Fine.
Now, what happened to Nodakhali PS case number 30 of 2025, dated 18th of January 2025?
Case has been started.
Yes. Show me the records of that. What happened? What is the investigation with regard to that?
I'm placing.
Show me the complaint on the basis of which this PS case was registered.
My lord. My lord, I'm sorry. Huh? No. Lord, this is the case records. This is the complaint.
I'm asking you, please tell me what has happened. What is the investigation? What was found out? What was the complaint? First, take out the complaint, give it to me.
That's what I'm handing over. But case की progress है charge sheet कोথায় আছে? And your lordship will find the charge sheet has also been filed after investigation is complete. Now you read yourself with this.
This complaint was made on 15th of January 2025.
15th of January. Yes, yes. আমি কমপ্লেনটা পাচ্ছি না কেন এখানে কোথায় আছে
15th of January 2025.
18 January.
18th or 15th. 18th it was registered. I find it was received on 15th of January 2025.
15th January and case registered on 18th. Now your lordship will find from the first page formation.
Yes. Give me a minute.
Receiving complaint, Lord, your lordship will find.
Give me a minute.
Occurrence 2 kilometers from information received on 18 January. 15 বলছেন কেন 18 January. 18 January case registered on 18. 18 January আপনার formation 15
No, complaint is dated 15th of January.
Why not?
Please see, Mr. Banerjee, please see this.
Kindly see the blood, the information received this.
Please see your complaint, your endorsement. দেখান
Case registered as 18
side this way
Date 15 January होते
and received on, please see, yes,
January. So this date
received on 15th.
18.
Which receipt? No. That is 15 January, they are later. But
Received on
18 January.
first line, first sentence. Received on.
No, this is 18 Milord. This is 18 Milord. This is 18, not 15.
That is 18. All right. So you have received on 18th.
The case started on 18.
Yes. So
And your lordship will find from the first page the form of the FIR. The information received, occurrence, everything was written. But that has to be written in the format. But
so you have
at least I have some knowledge.
you have the video recording of that incident of 15th of January.
15th of
January.
It was video recording.
My lord, we have video recording if my lord so deems fit and proper.
Mr. Trivedi, I have not asked you.
I apologize, my lord.
Mr. Banerjee, I will come back to you. I will come back to you. Now I am asking Mr. Banerjee.
De facto complainant submitted one video photography that was taken and that was given as an evidence in the charge sheet. In the charge sheet. Charge sheet has already been filed. That regarding incident, one videography has been given by the complainant, and that was taken into as an evidence, and it was mentioned in the charge sheet.
So it was, you have not videographed?
No.
So what happened? What was the complaint, Mr. Banerjee?
Which complaint?
What was the complaint? Please see that. What was written in that complaint? You have a copy of that?
Yes. In the report I have given. In the report I have given.
You have annexed the complaint in the report?
Yes. That
yes. Which page?
Page, pagination is not there. I'm sorry, my lord, your lordship, kindly pardon me. But after four pages, my lord, your lordship will find first.
Yes.
First information, then the next page, my lord, the complaint. Ami Mohan, may I read, my lord?
So on 15th, they have admitted they have been dispossessed from the shop room.
Complainant. Yes.
So this was within your knowledge. This case was being investigated.
Yes.
So
my lord,
I have not made myself clear. So this was being investigated. Now that is why in this context, what was your duty while implementing the order of injunction?
Yes, we have not. But the allegations, after breaking the padlock, we have given the position.
And you have found
that is not. And
correct. You have found both of them inside the.
Inside there is quarrel, chaos, and we have said kindly maintain the order of the learned court.
And Mr. Trivedi's client has left from there.
We have also left, my lord, to tell them kindly make the peace and tranquility.
But you have in the report you have said you have ensured possession. What is the meaning of this?
Ensured possession.
Yes, please kindly come to the third paragraph of the second page. How did you ensure possession?
On 1st July, another information was received.
Yes,
from-
that on 1st of July,
that
you
the
can
further-
read it.
Further depot was arrested his shop by Halim Mullah for enjoying peaceful possession of his shop. Accordingly, 1st July, the police, in compliance with the land court's order dated so-and-so, proceeded the premises of so-and-so and ensured peaceful possession.
Yes, how did you ensure?
Ensure
Because Mr. Banerjee, it was within your knowledge that they have been dispossessed by Mr. Trivedi's client, and on that date, you found both of them inside the premises, and you said you have ensured possession. How have you ensured possession?
ensured possession, if your lordship kindly see the order of the learned court below.
I am asking you, how have you
Yes,
ensured
yes,
possession?
that's why I
So,
want to show your lordship, show the order of the learned court below.
yes.
Because learned court below, while passing the order, your lordship kindly stand.
Permanent injunction restraining them from
No, not restraining. Not
Yes.
that. They are prior to that. What was the consideration?
Yes.
Third page, my lord. Third page from the
Of report.
Of the report. Third page.
Third page of the report.
Third page of the report.
Yes, yes, I have got. Yes.
Record is placed before me by way of put up petition so-and-so, ad interim injunction. It is transpired that as per the report of Seresada, no caveat is pending. This
You
is
can
an-
skip that. Mr. Banerjee, you can
Yes,
place from the last sentence of that page.
Not last sentence, but third paragraph.
Yes.
Fourth paragraph. It is settled notice of law postulates that while praying for ad interim injunction.
That are the three tests. Prima facie case, you can skip over.
Now, balance of convenience.
Yes.
The primary purpose of granting interim is the proportion property dispute till illegal rights, conflicting claims of the parties before the court are adjudicated, and at the same time evolve workable formula to the extent called by the demands of the situation, keeping in mind the pros and cons of the matter, dispute and so decline balance between. Now, considering the perusing the materials on record, my lordship kindly consider materials on record, the documents as filed by the plaintiff in support of his prayer, and the submission of the learned counsel for the plaintiff. This court is of the considered view that the apparently plaintiff is the owner and possessor of the suit property.
All right. Accepted. This order was passed when?
On Milord, 18th of December 2024.
And he was dispossessed in violation of the order of injunction. That's the complaint. That's the complaint. Was within your knowledge.
Violation.
He was dispossessed in violation of the order of injunction. That's the complaint dated. No, his complaint. 18th of January complaint letter. So he was dispossessed in violation of this order of injunction. That was also within your knowledge. So then you could restore the status quo ante. It's the police who can restore the status quo ante.
No, I have
Yes.
not.
How did you ensure possession?
Ensured possession, my lord. There is a
Mr. Banerjee,
there is a language. Lordship kindly see, there is a language which police authority has written, but he wants.
Banerjee, who went to the local on that day?
He wants to see.
Who went to the local?
This officer, my lord, second officer. And Lord, your lordship kindly
In
consider.
the GD entry book that is reflected.
Yes,
That the
yes,
second officer.
Yes, yes.
Show me that.
Yes. Your lordship
At
will
this,
find.
when they went, who went? Who are the police personnel?
আপনার নাম সঞ্জয় কুমার মন্ডল? Yes, SI Sanjay Kumar Mandal, your lordship will find. It is the possession. It is GD entry number 30 of 1st July. That is GD.
Mr. Banerjee, when they left the police station, this is the entry.
GD 20.
Show me
Yes.
who left the police station for the purpose of. This is the page.
But I am here.
When they
to
left,
answer all questions.
that is the GD entry when they left the police
I
station.
know your lordship. I will. বের করছি GD number 20 বের করছি 28 এই তো হ্যাঁ এই তো 20
Top. They said top.
Sanjay Kumar
Portion when they left.
Sanjay Kumar Mandal 20. Din possession. এটা আমি যে বলেছিলাম দিতে এখানে দেন এখানে ও এক্সট্রা গুলো আছে পাচ্ছি না কেন দিয়েছেন
So these are the persons who left.
my lord.
And then they found
And my
both of them in the possession. Both of them inside the room.
inside quarrel.
So
Quarrel. There is a chaos.
yes, so both of them were inside the room.
May I tell one thing? May I tell one thing? Let I bow down. Whatever your lordship will say, let I bow down. But not the allegations and accusations made in the writ petition that we have broken the padlock, and but that is not correct. That is why this is civil dispute, civil court, because police has nothing to do.
All right,
Police
take your
is
seat. Yes, Mr. Banerjee. Now it's time to hear you. Yes, Mr. Banerjee, can you go that side?
Oh,
Because you
চলে
will be
যাবো
having the microphone
আমি
otherwise.
যাচ্ছি যাচ্ছি এখন চলে যাচ্ছি জজ সাহেব বলেছেন আমি চলে যাবো
No, I'm not asking you to leave to that side.
Yes, side. Side change করো। যাও আমি আছি
No, since Mr. Banerjee said disputed that you had filed a report on the last occasion, that is why I required your presence.
আমাকে যা প্রিজার্ভ করতে যাও চলে যাও
Yes, Mr. Banerjee.
Two things, my lord. I am not very abreast of what has happened with regard to the police and the court. I've seen your lordship's orders. That is between your lordship and the police officers. No, I'm not getting into it. I'm simply addressing your lordship and from this being an order under challenge in a 227 application. My lord, a suit is filed regarding declaration and permanent injunction. It's an ex parte ad interim order. So the plaint case, the averments are taken to be true and correct. This order that my learned friend has just placed before your lordship for the state, your lordship has seen there was an order restraining them from disturbing my peaceful possession of the suit property as on 18th of December.
Yes. Yes, I have to note some of the things from your submissions.
I'm hoping I'll make submissions worthwhile of being noted.
No. Yes. Yes. Mr. Banerjee, you can.
So 18th of December 2024,
yes.
The order your lordship has found.
So 18th of December, an ad interim order of injunction was passed.
That's right. At page
and restraining Mr. Trivedi's client from disturbing your possession.
That's right.
So that's the order?
That is the order. I'll just 63. The defendant and his men and agents are hereby restrained from disturbing peaceful possession of the plaintiff.
Page
62 is the order. The operative part is at page 63.
62 to 63.
63.
Yes, what happened after that?
This order is still in vogue. This order is still subsisting.
Yes. What happened after that?
14th of January,
yes.
I make a complaint your lordship has found that was dated
not 14th,
15th. And that complaint I'll just read out. No, that is from the
15th of January 2025.
15th of January 2025.
Yes.
This injunction is there till the 16th. Has anyways been extended from time to time.
We shall proceed that order of injunction, ad interim order of injunction is still continuing.
Yes.
We shall proceed on that basis. Yes.
Now
what happened on 15th of June?
So this police complaint that I filed.
Yes. What is the substance in the police complaint?
So that only bit that I need to probably indicate, because that has that's something that your lordship has also taken note of, that they have come, snatched whatever documents I had in the shop room. They've taken some money from the shop room and they've come and put their own padlock.
So that's the complaint admission.
That is the complaint. That is my complaint.
So, yes, that's your complaint. So you have to stick by your complaint.
Yes.
You cannot. Yes.
That is my complaint.
Mr. Trivedi's client has put a padlock. So you have been virtually dispossessed on 15th of January or 14th?
On 14th.
So,
because that is the date 14th. Kintu goto 14/1/2025 tarikhe.
Yes.
Punorai amar.
What is dispossessed on 14th of January 2025?
The padlock, yes.
So where is that complaint? Do you have a
so that was a part of my writ petition. It is not here.
Yes, but you have filed your writ petition also.
Yes, I have filed the writ petition also. That's separate. That
so after that, you approach the writ court.
After that, I approached the writ court.
Yes.
For police inaction.
So, yes. Please take me to the pleadings of your writ petition.
Page 80 কোথায়? আমার তো এখানে 70 তে শেষই হয়ে যাচ্ছে.
79 the first complaint on 15th and page 80 is the second complaint on 18th.
Please come straight away to paragraph 13 of the writ petition.
Yes, my lordship will just give me a minute.
80 নম্বর পাতায়
70 80 তো নেই আমার এখানে. 80. But there appears to be another complaint to the officer in charge, which is dated 15th of January. Goto 14 it's the same, Lord.
Yes.
Yes.
So
This is
paragraph
of the-
13 onwards, you can proceed.
Of the writ petition.
Yes.
Yes.
That's your case.
In the writ, Lord.
Yes, yes.
That writ has been now disposed of. With
Maybe.
order.
Admissions remain, Mr. Banerjee. That's the law.
I'm sorry, Lord.
Admissions in a proceedings, statements remains. It will go on forever.
Lordship will take my complaint only as an admitted. If I
Yes, yes,
take
yes.
that
Let-
as an admitted.
On oath, Mr. Banerjee, you have stated this. Please place from paragraph 13 onwards.
Aggrieved by the aforesaid acts, your Lordship is looking at WPA 3437 of 2024.
I think this is the only writ petition.
Act I writ,
Yes,
no?
3437.
Yes. Aggrieved by the aforesaid acts of respondent number 4, the petitioner was constrained to file a complaint with the respondent by virtue of a letter dated January 15, 2025, inter alia conveying the respondent number 4 had this. It should be dispossessed, I think. The
Yes, it should be
petitioner
dispossessed.
should be dispossessed. The petitioner from his shop in the said property by inflicting physical acts of violence on him and his property. The respondent number 4 and his men and agents also snatched away the keys to the said property from the petitioner.
Then you can
illegally-
skip, kindly come to paragraph 16.
16. Yes, Manoj. On account of the aforesaid inaction and or omission of the respondent
The
authority.
previous is allegations against Mr. Banerjee's client. Inaction, police did not take. Then paragraph 16.
Paragraph 16.
Yes, place paragraph 16.
On account of the aforesaid inaction and or omission of the respondent authority, the petitioner sent a letter dated January 22nd, 2025 to the respondent number 2, which was received by the respondent number 2 on January 22nd, 2025. In the said letter, the petitioner interior requested the authority to restore the
Please take
possession
me
of
to
the
that letter of 22nd of January of yours.
which is P11
Yes.
in the writ petition.
Page.
Right. Yes, that is at page 69.
Yes.
This is dated 22nd of January 2025. বিষয় এই মোড়ে টুলটুল ভান্ডার মুদিখানা দোকান তালিমায় দেওয়া মহাশয়, আপনার নিকট আমার বিনীত নিবেদন এই যে আমি প্লেন্টিভস নেম আমার 18/1 তারিখে আবেদন জানিয়ে বললাম আমার সেই ছোট ভাই কিন্তু মুক্তি থেকে সংস্থা নিয়ে তার দোকান টুলটুলের মধ্যে ঢুকে আমাকে মারধর করে এবং আমার দোকানের চাবি জোর বশক ছিনিয়ে নিয়ে আমাকে জোর পুলিশের সামনে ব্যস্ত করে। আমার উপরে উল্লিখিত দোকানে তালা লাগিয়ে দেয় 22nd January 2025 তারিখ।
Mr. Trivedi's client has put a padlock on that date.
I'm sorry, Milan.
Mr. Trivedi's client has put a padlock
He's
on
put
it.
a padlock as on
And
22nd. I am still outside the shop. That is
And
why
the next is very important. Next sentence.
22 তারিখ এখনো পর্যন্ত দোকানটি বন্ধ রয়েছে।
Yes.
আমার সংসার সারা পুরি এই দোকানটির উপর নির্ভর। আমার সংসার পুরোপুরি দোকানটির উপর নির্ভর। স্যার আমার কোর্টের আবেদন আছে,
কোর্টের আদেশ আছে।
হ্যাঁ, আদেশ আছে
এবং
একবার
বারবার অনুরোধ করা সত্ত্বেও থানার পুলিশ আমার তালাটি খুলিয়া দিয়ে
সাহায্য
করছে না।
আমার
inaction against the police that they are not taking steps for opening the padlock. So it's in the padlock put by the Mr. Trivedi's client. You are dispossessed.
Yes,
please now come to your reliefs claimed in the writ.
In the writ, yes.
Yes. Prayer C.
Writing respondent number 3 to forthwith take steps to restore the petitioner to peaceful possession of said property and ensure.
So restoration of possession is the prayer in the writ.
Yes.
This writ petition was filed on.
No, this writ petition was filed on 11th of February 2025.
So that is a very relevant date. 11th of February
2025.
So writ petition filed.
Yes, no.
Praying restoration of possession.
Yes, no. This is disposed of by the order.
Yes. So in that writ petition,
yes,
a report was filed.
That I don't know. Report was filed.
I think in the order it has been recorded.
Page 64. Page 64.
Kishe 64
Page 64 of my app. The order of the.
Report submitted be kept with the record. Yes, Mr. Banerjee. Where is the report filed in WP? I have asked you to bring that report. Please give me the report.
Another order. Another order of the landlord. An application was filed.
I will come to you.
15th of May 2025.
I will come to you. Please give me. I will proceed stage by stage. I will hear you again. Because Mr. Banerjee's client was not given any opportunity. Only one submission was recorded. That is why I have called up Mr. Banerjee and he was very eager to make his submissions from there.
Could I just beseech your lordship to come back to 64, my lord?
Yes.
Petitioner submits, second paragraph.
Yes.
Petitioner submits that there was a specific order passed on 18 December so and so.
Yes.
The said interim order is extended, but in the meantime, the private respondents flexed their muscles and took possession of the grocery shop, thereby violating the order of the civil court.
Yes.
Learned advocate for the state has submitted a report. This your lordship will examine. Reflects on 18 January. PS case number so and so registered for investigation by the police authorities and necessary steps be taken.
May I hand over the report?
Well, if your lordship could just may I just beseech your lordship and relying on the next two paragraphs of this order. DDS Supreme Court যে তিনটে জাজমেন্ট আছে ওখান থেকে রেলেভেন্ট প্যারাগ্রাফগুলো বার করে রাখো যে 151 কোর্ট ক্যান ডাইরেক্ট রেস্টোরেশন অফ পজিশন রেলেভেন্ট প্যারাগ্রাফ বার করে রাখো ওসব ছটফট করছো কেন ঠিক আছে
Yes. Yes, Mr. Banerjee.
Yes. Learned advocate for the private respondents submit that since on the self-same cause of action, take out the relevant paragraph. Self-same cause of action, petitioner has approached the civil court. The present petition should not be entertained with the same consequences as that of the civil court's order. I have considered the submission of the respective parties, and it has been informed that the application under section 151 of CPC is pending before the learned civil judge in respect of rendering police assistance for violation of the order passed by the civil court. Please mark henceforth, my lord, I am of the view that if the civil court directs the police authorities to act in a particular manner, thereby rendering police assistance, in that case, the police authorities would respect, obey, and implement the order of the civil court.
That I want to show. Lord,
So this is there in the
15th of May.
Act minute. This is there in the writ petition. My lord, my 151 application was pending. This honorable court directs the police that if the civil court passes an order, you will obey that order. I go back to civil court, 151 application is taken up.
Yes.
Kindly have a look at this impugned order once, we're not here.
Yes. That is the impugned order.
15th of May 2025.
Yes.
Learned advocate for the plaintiff, learned advocate for plaintiff submitted for police help to maintain the order and so and so. It is alleged by the defendant disregards this. Please mark the next paragraph. My lord. It is the duty of the court. It is the duty of the court to see that its order be properly implemented by parties to the suit in its true spirit and sense. Accordingly, so and so is hereby directed to see that the order dated 18 December passed by this court in this suit is implemented properly by all concerned according to its true spirit and sense. Well, look, I get the injunction on 18th of December. This is an ex parte ad interim. The injunction order is restraining him from interfering with my peaceful possession. I come up to High Court. High Court directs the police that since the 151 is there, you will obey with what the 151 court or the civil court directs. Civil court directs that you implement this order. This implementation, now your lordships have laid down the law, my lord. 151, I don't have to go under 39(2)(a). 151, the court has the power to, these words that your lordships use, is to set the wrong right. So now when it talks about implementation of the order of 18 December, it is the situation as on 18th of December.
Show me your 151 application.
Yes, ma'am.
Page 74.
Page 74, your lordship will find my application.
Page 74.
Yes, ma'am.
Yes. Show me
that I have stated that I am dispossessed. Not there.
Then
no, only
suppression, Mr. Banerjee. Suppression.
Today
you have obtained this order by misleading the court. You have not made out the case that you have been dispossessed subsequently. You have misled the court. That's the sufficient ground for recalling of that order.
kindly comes back to page 75.
Yes.
My lord, today, a party who is
Mr. Banerjee, have you disclosed this?
I'll place the paragraphs, my lord.
Yes.
I'll place the paragraph.
Yes.
My lord,
Have you disclosed proceedings in the REIT code? What have you done? Have you said those things?
No, that is not here.
So,
But
you approached Mr. Banerjee, the civil court.
Yes,
You
my lord.
obtained an interim order of injunction.
My 151 was pending, my lord.
Mr. Banerjee,
Which is
please,
why
please allow me to make my
Yes.
observations.
Yes.
So then you come back to the High Court, say that yes, I have been dispossessed. Please restore my possession. High Court in the writ petition says no, 151 pending. Go back. Show me that these facts you have stated in 151.
Look,
When this 151 was filed,
151 was pending, which is why the learned, but this honorable court records in that order, not in the writ petition.
yes.
So 151 was before.
So the 151 was before when? When it was filed, I'm asking you. Tell me when it was filed.
10th,
7th of February.
10th, 7th, उल्टो पल्टा date बोलছেন কেন? 7th of, I'll just indicate.
7th of February 2025.
7th of February 2020.
When you were dispossessed, Mr. Banerjee, show me that that fact has been stated in 151.
Just bears with me for a minute. Comes back to the application.
Yes.
Paragraph 4 onwards.
Yes.
Before that, my lord, paragraph 3 is important. My lord, your lordship is looking.
Yes.
Your lordship is looking at conduct. Your lordship will look at my conduct and his. Today, one party has assailed a 151 order where at least now it is ex facie
Yes,
evident.
you can place this. You wanted
That's one bit of it. Bears with me for 2 minutes. My lord, conduct is something that your lordships have always looked at for grant of an equitable relief like an injunction. Your lordship is testing my conduct. Your lordship has called for the police, all of this to see examined. Gives me 1 day, I will produce this CC. Your lordship has looked at all the other things which are strictly beyond.
Please.
I'll come. I understand. The court is not with me.
Please show me
What
that
was before the learned civil judge.
Yes.
Yes. Paragraph 3 is important. You know,
Yes.
that the order of the learned court has been duly communicated to the defendant through registered post with AD.
Yes.
And the defendant is aware. So at least I pleaded knowledge.
Yes. No dispute with regard to that.
No, but if he knows and then he violates, your lordships have never countenanced that.
Yes.
If there's a violation of the order despite knowledge,
show me the violation.
That despite knowledge of the order and its spirit, the defendant and his men and agents are violating the order of the court, which was passed on 18 December. The defendant on 14 January, along with his wife and 2 daughters, entered the shop room and started threatening me with dire consequences. Suddenly, the plaintiff, to his utter surprise, found at least 10 to 15 people of the locality who are politically backed tried to enter the shop room. The plaintiff vehemently objected to such activity and tried to expel the persons out of the suit shop room. Suddenly, the wife of the plaintiff and his daughter started beating the plaintiff and snatched all the diary and khatas of the income and expenditure from the suit shop room and tried to evict the plaintiff with muscle power. The plaintiff, being aged and infirm person, tried to show the order of the learned court to the local persons, but in vain. So I pleaded all these. The plaintiff immediately called the police and the police authority rescued the plaintiff from the situation. The plaintiff lodged a written complaint and prayed for immediate action, and the police authority lodged FIR number on 18 January 2025 against the said plaintiff and his wife and 2 daughters who have been physically beaten and harassed.
The very basis of this application was that you are in possession. Very basis of this application is that we are in possession. They tried to.
How your lordship reads it. When I write that I could not, but it was in vain. In my understanding, it was there that, and anyways, would not have disclosed.
Mr. Banerjee, you could write so many words. You could lodge a complaint. You was very clear in that. You was very specific in making a prayer for restoration. So you could not write one line that they have put a pipe law.
May I say this? Well, your lordship is hauling me up for a suppression in a line before an application and letting go of a party who, despite having knowledge of an order, has violated the same. Well, if your lordship is relying on that 14 January, my complaint, and that is to be taken to be true and correct here to understand my conduct, then it is on 14 January I am getting dispossessed, and that person is standing before the court today.
Dispossessed or you have been dispossessed?
I have. Let us say dispossessed. Your lordship is testing my conduct on the basis of a 14 January complaint.
Mr. Banerjee,
in that complaint
there. So what's the remedy when a person in violation of an order of injunction is dispossessed?
I have, your lordships have never, may I just understand this? The court
After all, this is an
for
identity
2
order of
minutes.
injunction.
For 2 minutes.
Yes.
Let me understand this. This 14 January complaint is taken to be the parent document based on which the entire facts are being ascertained today. 14 January complaint, if it's taken to be the mother document, states I am dispossessed by this defendant on 14th of January. Dispossessed, I take that case. So today, this person, because if I can show other facts, I can show other facts. But your lordship is looking at the 14 January. This conduct can't be countenanced because 14 January I say, and which is why I placed paragraph 3, that he had full notice and knowledge of the order of 18 December. There is no vacating of that order. Your lordship is now ascertaining my conduct because 14 January I don't disclose, though I have referred to the 18th January, but countenancing the defendant who on 14 January dispossesses me contrary to an order of court, because there is no gainsaying, my lord, this is an admitted position. The order was there that I am in possession and restraining him from disturbing my peaceful possession. How does the police go and find, and how does he come into possession of the property? He comes and puts a padlock, and High Court under 227 will sanction that kind of a conduct here. And 151, my lord, I am personally aware I will not have to place judgment that 39(2)A is not my only remedy. 151, and I consciously use these words because you know, time and over again used it to set the wrong right. So if I look at it this way, where 14 January is the basis on which I am being crucified, then 14 January is also clearly exemplifying the fact that this petitioner before your lordship throws me out on 14th, when the interim order is there from 18th of December to 16th of January. What does the High Court say? High Court says you go back there, this is going to be implemented. Whatever order civil court passes what? Even if I had not said that I'm in possession. 151, when I file the application, court directs that disregards all this application, my lord. Court directs implement my order. Verbally, your lordships have the power to do it. When I come before this court, verbally, your lordships can do that. That implement my order till my order is set aside or varied. I will have my order implemented. This is, but otherwise there is no point for lower courts to pass these orders. For everything, you have to come under section 10 before this court. If the court can't pass this order that you implement my order, fortified by the High Court decision, that whatever order the civil court passed, the police will implement. Court says implement my order. And here comes another party saying, relying on suppression, saying 14 January I have gone and in violation of it and dispossessed it. And he comes before the High Court. Lord, when I was having this conference yesterday with my junior, I really wanted to indicate just these two facts. If conduct is something that the courts have always insisted upon, how does this petitioner come and get out of this? Saying there is an order passed by the civil court on 18th of December, I have dispossessed him on the 14th. And you set aside this order of the police have come and done. What has happened, I don't know. Police reports I have also not seen. I really did not get the time. But this is there. If your lordship is testing my conduct only on the basis of 14th.
So you had dispossessed on 14th of January.
Well,
when you came into possession and how you came into possession?
Before that. Before the suit.
14th of January 2025, you are dispossessed.
Yes.
So
before the time
after that, did you at any point of time come into possession of the suit shop room?
Well, now I'll show you, lordship, what has happened while the matter is pending.
No, I'm asking you. Please give me the data.
This order that is assailed before your lordship has not been implemented. What is happening, my lord, and forgives me.
But are you in possession? Are you in possession or you are not in possession?
Kindly have a look at this. What has happened? Please have a look at it.
Yes.
This is what has happened now. Lordship will appoint a special officer and go and see. But your lordship has called for a report from the police. Appoints a special officer on my cost. My client can't pay, I will pay.
No. I'm asking you, are you in possession?
Look, the local people have gone and put a bamboo. They've put their own padlock.
You are not in possession.
Look, if I put it this way, the order passed by the civil court has been prevented from being implemented. The order is simple.
So I take your words, you are not in possession.
No,
as on this date.
No,
as on this date.
I was.
You were in possession till 14th of January 2025.
And then someone in violation.
Yes. You have been dispossessed wrongfully in violation of an order of injunction, taking the law in its own hand. In front of the police personnel. They have snatched everything. Okay. Now I am asking you, after 14th of January 2025, did you enter into possession of the shop room at any point of time?
No, your lord, I am told that we had filed a 144. Pursuant to that, we could go in for 2-3 days. Again, we were thrown out. And now, pursuant to your lordship's order, there's a padlock. Well, today,
that on 1st of July, where were you? 1st of July 2025.
So that 1st of July was when.
Please don't rely upon the police reports.
No,
police report I didn't even
That is why I'm taking instructions from him.
I'm asking you, I take instructions from.
Of the order of 15/5/2025.
Because police report I will explain later.
First of July, Alimony after that they have come for its application and then padlock is.
So 1st of July, I'm told that compliance was, they went to comply with the order of 15th of May, and that compliance, probably full-fledged implementation that was directed by the 15th May could not be done.
I am asking you one question, answer in one
As
word,
I stand before,
whether we were in possession, whether you entered into possession on 1st of July 2025, yes or no?
Yes or no? Achhe log mocktail achhe. Just 30 seconds. I'll just ask. This I wouldn't know. Yes, I was there. My client is here. He says he had gone in.
How could you enter into possession?
1st of July ঢুকেছিলেন দোকানে? হ্যাঁ? কি করে ঢুকলেন কি করে? কবে ঢুকেছিলেন? আপনি বলুন না। দোকানে ঢুকেছিলেন কবে? 1st জুলাই? তারপরে? তো বেরিয়ে গেলেন কি করে? না, তারপরে ছিলেন? প্যাডলক লাগা অবধি আপনারা ছিলেন? ঠিক তো? So from 1st of July, he's saying I was there till the padlock was put. He's here.
Till the padlock was put. So there was a padlock put by Mr. Trivedi's client.
No, pursuant to probably your lordship's order. 1st of July.
That is your complaint. He has asked you put a padlock.
I asked him regarding 1st of July.
Mr. Banerjee, it will be a continuous process. So your allegation is that 14th of January, you are dispossessed. Mr. Trivedi's client has put a padlock. That is why I'm asking you, how could you enter the suit shop room on 1st of July 2025?
Probably from, still, 14 January 2025 সালে যখন আপনাকে তালা চাবি দিয়ে বন্ধ করে দেয়, তারপর ঢুকেছেন কবে আবার? 1st জুলাই? ফার্স্ট জুলাই পুলিশ গিয়ে ঢোকায় নাকি তার আগে? দুজনেই ছিল 1st জুলাই। আপনি আমি জানুয়ারি মাসের 14 তারিখ থেকে জুলাই মাস অব্দি কি একবারও দোকানে ঢুকেছিলাম? তো তালা বন্ধ করে দেওয়ার ঢুকতে পারিনি। তো ঢুকেছেন কবে আবার? 1st July. 14 January to 1st of July, I was not there. 1st of July, during implementation of the order.
How do you enter? That is why I'm asking you. What's the mode of entering into that property?
Well,
this was under control of Mr. Trivedi's client. How could you enter into that?
He's saying that the lock was open, he went in. He's there, that is what is there. But today, I am on a slightly different point. Let us take it that even as he stands here, he is dispossessed. Disregards all of that. Forgives me, Lord. What does the High Court do here? What does the court do here? And I very consciously put this question to myself. Here I stand with an order of injunction passed by a civil court on 18th of December saying I will not throw me out. I will not be thrown out. Here comes another person with a complaint saying I've suppressed on 14th of January. I have gone and put a padlock. Which person's conduct and what does the court do with that order passed by the civil court? Civil court directs implement my order. It is nobody's case that a civil court can't implement its own order. Your lordships have always allowed that. Who is in possession? Whose right was it in possession? That is before the civil court today. He has to go and contest that application. Let us look at it differently. Tomorrow, if I come up from an ex parte order of injunction, which I don't challenge.
Mr. Banerjee, one question, please.
Yes, ma'am.
The example which was given to Mr. Banerjee. So let us take a hypothetical case, not this case. A obtains an order of injunction.
This situation is going to go against me, I know, but I will.
You have to explain that.
Yes, ma'am.
So an order of injunction similar to the case on hand has been passed. Now, on the very next day, the A applies for police implementation. That was allowed. Now, police goes there, finds B in possession. So, police is authorized to take out B and put in A by way of implementing the order of injunction.
Let us take
or what should be, according to you, the action of the police in a situation of that case?
Asks me as an officer of the court, I will say 100% yes. If there is an order passed on 18th of December, and now I'm saying this as an officer of court with full responsibility. 18th, why civil court? Your Lordship passed an order of 18th of December that I will not be thrown out. 19th, I come and tell your Lordship I've been thrown out. Your Lordship directs the police or the sheriff to go. Police will not put me back. I will come to court and justify saying no, 151 court does not have power. Well, let's not look at the civil court, junior courts in a different way. Let us say I am before your Lordship today. Today, your Lordship passes an order, I will not be disposed. Tomorrow, I'm thrown out. I come before your Lordship. What happens, Vinod? I'm saying this not as a counsel. This, your Lordship, is for whatever it's worth as an officer of the court. Because this has to be upheld. This gimmick can't happen. This thing of when, what, who, there is an order of court. And it is for the constitutional
authority in your support for this proposition.
The court will set the wrong right.
No. In this case, where in violation of an order of injunction, somebody enters into possession, police can throw him out by way of implementing that order of injunction.
Yes.
Please show me.
Keeps it tomorrow, I'll come back. Gives me a day to the point where I'm carrying other judgments which say court can use 151, but if I'm not mistaken,
151 for
implementation to set the wrong right in these 4 words.
Mr. Banerjee, that's a different thing altogether. Here, my question is an entirely different thing.
I understand. Milord, I understand.
I'm not for a moment suggesting that the court under section 151 does not have the power.
May I just?
I'm asking you, if the police goes there, finds there is an order of injunction in favor of A and against B, finds B in possession.
I follow.
So, what should be the duty of the police at that point of time? My question is that I'm not asking you.
No, I understand.
That
Lord,
151.
The police did not throw out the
That you have said. Mr. Banerjee, I'm asking.
To restore this language you'll find in judgment.
And order of the
That you have submitted, Mr. Banerjee.
Lord, may I? Yes, I'll disregard the police. I'll answer this on a question of law only. Lord, may I?
To file a report before the civil court whether my order has been implemented or not.
Lord, could I just ask?
Good luck.
Have you filed the report? Have you prepared that report? Have you prepared the report? What will be your report?
My lord.
No.
No,
That
report.
report. Implemented.
No,
You have implemented according to you. Mr. Banerjee, you have implemented because I can take your report which you have filed. That's in compliance with the. Yes, you have filed. No. You have filed saying that you have complied with ensured possession.
But
before this court, that will be a different report. Can't be a different report because here I asked you because my previous order was what steps you have taken to implement. That was my specific first order, and in reply to that, this is the report.
Ensured position.
Yes. So you cannot file any other report before the trial court.
No. What is the fact? We have not.
That is why I consciously used the directed you to file that.
What do you before your lordship?
Lord, I will. Lord, let us not
understand to that party. Kindly comply the order. Thereafter, you can take steps.
That is this. What he's saying.
Yes.
This what he's saying is exactly what my client standing there told me. That the police went, showed his clients, Mr. Trivedi's clients, the order, and was told that you can't do this as contrary to and the lock was open. He went in.
I have spent some years there.
No, I don't want to go into this.
Mr. Banerjee, you lodged a complaint. So on the basis of the complaint, police did not take any steps. So you alleged inaction on the part of the police. You approached this court.
But
you obtained that, Mr. Banerjee. So you paid for restoration of possession. There also court did not. Then also police did not help you. And on 1st of July, only they requested them and they fled away. Mr. Banerjee, it's very difficult to digest.
Today,
It's very difficult
may
to
I
digest.
just very well.
Mr. Banerjee,
Very well. Disregard.
spent some years there. I know.
Very,
I know how this has been done.
15
No, but-
kindly see. What?
15 May I will come, Mr.
Yes.
That will be my final order, Mr. Banerjee. Yes.
Yes. But
That will be my final order.
thereafter we went over there.
This
And it is
this
dispute
thing
between
with regard
brothers.
this police thing is only making it more cumbersome for me. I am on a different, just on an issue of law. I'm on a different issue of law. But I don't want to get into this report and all that. But let us say in the hypothetical situation that your lordship gave, I come before this court and your lordship is taking the interlocutory bench in the original side. I come up before this court and say that I am getting dispossessed. They should not interfere with my possession. Your lordship restrains the defendant from interfering with my right of possession. The next day I come to court and show a video and say, look, on 19th, they came and they threw me out. Actually, and they threw me out. What does, forgive me, I'm framing a question, this, your lordship will just forgive me on that. What does the court do here? Today, when the civil court directs implementation of this order, coupled with the High Court order, which says because High Court order is also implementation. So I am on one aspect. When implementation is directed, implementation will naturally mean status quo ante. Otherwise, there is no implementation of this order.
For getting the status quo ante, what do you have to show?
That there is a violation?
Yes. Show me from 151 that you have alleged that how it has been violated and how it has been implemented. Show me from your 151.
Your lordship is
151, Mr. Banerjee.
I understand.
151, your allegation is that they are disturbing your possession.
That's right. I understand that. 151, your lordship is holding me for suppression because on 14th...
Not a suppression.
No,
Mr. Banerjee, not a suppression. Let us take it that you have not suppressed.
No, let us take it, I have. Your lordship will take it for the sake of argument. Don't record that. For the sake of argument that there is a 14 January, I'm dispossessed. Your lordship is looking at that complaint in a different repetition to understand that my 151 application pleadings may not have been correct. But if the 14 January complaint is taken to be true and correct, then this defendant in violation of an order...
Show me that yes, show me that complaint was taken into consideration while passing this impugned order.
No, it was not taken. This is what I'm trying
to say. So what was the basis on which this order was passed?
Today,
what was the basis? Show
the
me.
application that was there.
Yes.
So
show me the court's consideration.
Can I just repeat myself once?
Show me the court's consideration. Now you are trying to support the order. Yes, please show me what's the reason assigned in the impugned order.
Yes, comes back to the impugned order.
Yes.
Please have a look at the fourth paragraph.
Yes.
It is alleged by the plaintiff that in spite of order of injunction passed by this court against the defendant is violating the order dated 18 December.
In what means?
The moment there is a violation...
Your allegation? Now, court's finding with regard to your allegation.
It is the duty of this court.
So merely Mr. Banerjee alleging, right, then 151 police help will be allowed. Can you show me a decision on that? Mere allegation, yes, straight away police help, 151, please show me. And for implementing an ad interim order of injunction, show me.
Well, may I just say this?
Show me that.
May I just say this? 151 application when it's made, I go up to the court, let's say I come here and I tell the court that there is a violation. This order is in vogue. As long as the order is in vogue, its implementation can't be.
The example, Mr. Banerjee, the example which you have given before the interlocutory court, you said that there is an order of injunction passed by.
I understand that I came and showed a video.
Yes. Yes. Show me that. What was the material before the court for passing this order of implementation? Show me.
Paragraph 3?
Yes. It's only allegation, nothing more than that. Mr. Banerjee, for passing an order directing the police to implement, there has to be some material to show that it's only your allegation. Show me court's recording once. Court is satisfied with your allegation. Show me.
It's there. Your lordship will look at This
Which
one
paragraph?
line, my lord, it is alleged by the plaintiff.
Yes.
And then it is the duty of the court.
Mr. Banerjee, alleged duty.
Sir, your
Show me,
lordship is,
Mr. Banerjee.
your lordship is minded to interfere with this order because it's an unreasoned order.
That is a different thing altogether.
No, my lord, that is
I'm
what I'm
saying
meeting.
the example which you had given,
Correct.
when the court will
Lord,
pass,
this
that's
example-
lacking here.
Well, this example, your lordship is disbelieving because my 14 January, I was dispossessed. My dispossession on 14th of January is in a complaint which was before this honorable court. This honorable court also directs that in terms of the order passed by the civil judge, you will implement that order because your lordships have always, well, these are constitutional courts. 226, 227 are basic structure courts. And implementation is something that your lordships have never interfered with. Here comes one petitioner before the court, and if your lordship and I are relying on this 14 January, he can't come and say, I'm not dispossessed. If your lordship today finds I'm not in possession, forgets this order,
150
your lordship can do that.
Police help, what are the guiding principles court should consider while allowing police help? Show me.
Civil rules and orders is something else. I understand where your lordship is taking me. I will not walk down that road. This is something else. Your lordship wants me to look up the law and come back on whether under 151, because I've answered one query as an officer of the court. As an officer of the court, I'll go back and do that research. In my understanding, and if my memory doesn't fail me, I have come across judgments, which I also believe your lordship has come across. That
on what point?
That to set the wrong right in including by directing police help. I found these 4 words somewhere. I'll try and come back. But one thing, Lord, in my 20 years, I've understood. If I can't satisfy the conscience of the court, no amount of law or judgments that I show will ever be of any help. So it is my first duty on facts to satisfy your lordship's conscience, because I understand that the court believes that there is a connivance that has happened between me and the police to throw this petitioner out. Forgets everything else. This allows me to satisfy the court's heart on this. Because if I can't do it, come what may, what I find, what he finds, it won't make a difference, because your lordship is a court of conscience. It is my responsibility first cross that hurdle. And it is that conscience that I'm appealing to today, and very consciously, that here comes 2 parties with one order of court. One alleging it's been violated. The other one saying that look at this, he has gone and not told the court of all the facts. And from one, it appears that on January, there has been a breach of that order. Disregards that. When it comes to implementation of an order.
When you filed 151, please give me the date.
February, 7th of February, 7th February 2025.
Yes. So 7th of February 2025, you filed that application 151.
Yes. And 15th May 2025 was passed on contest.
And 11th of February, after 3 days, you approached the High Court.
Yes. And I come and tell the High Court.
Yes.
But how many points do I meet here? Your lordship is up against...
Mr. Banerjee, you know.
Yes, yes. Well, this is where I must say I'm a little surprised. Your lordship is testing my conduct with the petitioner having violated an order of court.
Mr. Banerjee,
will forgive this exchange.
Mr. Banerjee, you must have come across decisions which says the courts have been cautioned. It's very difficult, and courts are do not or refrain usually from implementing an ad interim order of injunction by police help, because it's only the ad interim order of injunction is only an ex parte order, because at that point of time, whether you are at all in possession on that date or not, it's cannot be decided.
December 2024.
So
now that I have a host of points to meet, let me come back on a day that your lordship is not so against me, and I'll try and come back with something better.
Mr. Banerjee, it's not that it's against you. Mr. Banerjee, it's only a point of law, because this has to be set right. Because let us take a hypothetical case. I'm giving a different thing. A person is
not there at all.
Yes,
That's, I
So
follow
it's
that
the
is there.
status quo ante means.
This much
what
credit your lordship will give me. I follow that is troubling the court. That I was never there. I got the injunction,
So
came back and tried
status
to
quo
go in.
ante means status quo which was existing as on the date of filing
But
the suit. Now suppose he was dispossessed. Let us take a few days back. So you were dispossessed, you were in possession, but you were dispossessed just prior to the filing of the suit. But you have all documents to show your possession. You approach the court, obtain an order of ad interim injunction, then you say in violation. So court has to come to a finding whether this was violated or not. For that, it's very difficult on an ad interim order of injunction.
No, let me look this up. I understand. I stood up before the
Because I
court. I
think
understood
this point has
what
to be
is
set right.
I
Whether
understand. This
under
is
ad
what is
interim order
troubling
of
the court.
injunction, because repeatedly ad interim, this is a
That
state
somebody
which is
was never there, gets
ad
the
interim
injunction.
order passed, then 151, then police in action says police do this.
That gives me this query. The different things that your lordship has required me to look up. Keeps it anyway.
What is the submission?
My lord, as far as since my learned friend, my lord, he has not understood what I pleaded at the initial stage before my lord. My lord will kindly appreciate, has rightly fallen.
Mr. Banerjee, don't hear Mr. Banerjee here. What is Mr.
It is my
lordship is allowing me to come back another day.
Let me see. Please take
No, then there are some. It kindly gives me another day.
Judgments.
But
judgments you will bring. Please
but
take
then one thing your lordship will just keep in mind that this order of 18th of December 2024, I don't know if they filed a written objection to that. There is at least no vacating. So if I have gotten an order which is on suppression, I was actually not in possession, I have suppressed something, it was well within the rights to go and file a 39-4 to have this vacated. Till May 2025, and if I'm not mistaken, even today.
December, that order of ad interim order of injunction was passed. Till which date that will be remain in force?
Till it's extended,
Yes, no, first order.
16th of January 2025.
And you have been dispossessed on 14th. That is very relevant. So,
but they would not file a vacating,
Mr. Banerjee, if they are in possession, why they will you go for violation? There everything will be proved. They are not required to, because they are in possession according to
then everybody will take the law in their hands. They've got the injunction.
To them, they have not dispossessed you. They were all along in possession.
So that will have to come to court and have that order vacated, If your lordship's order is there, I will say I will not challenge it because it's wrong.
Yes.
Yes. Two little things. Initially, when I came before my lord, it has my unequivocal contention, lordship, that I was always in possession. It is a dispute between two brothers who enjoy the same periphery of property. Now, but I was always in possession in my written statement, which is filed before the trial court, and even in my objection to the 151 application, where all the series of documents.
Show me that 151 application objection.
My lord will kindly come to page 81.
Yes.
Now, my lord will kindly take up my page 81 is my objection. Now, my lord will kindly say, see, my lord, first I say in paragraph 2, the plaintiff has no cause of action for filing the present application, that nobody has been dispossessed. Now, my lord will kindly come to paragraph page 7, where I have dealt with paragraph 4, which was vehemently put forward by my learned friend. Paragraph 4 of 151.
Paragraph 4 of
151, how I have dealt with paragraph 4 in page 82, paragraph 7.
Paragraph 4 of 151 is in which page?
My lord, paragraph 4, my lord, will kindly come to page 74, my lord.
74.
75. 75 vis-a-vis 82.
75, yes.
That
13th of January 20.
Yes, my lord, what has been placed by my learned friend vehemently, that there I did not say I was dispossessed, but everything else around the corner, I say how I have dealt with that.
Yes.
My lord, I am placing page 82 paragraph 7. That the statement made in paragraph 4 of the petition are false and are denied. It is false to say that despite of the knowledge of the order of the defendant and his men and agent are violating the order of the court. It is equally false to say that the defendant on 14/1/2025 along with his wife and two daughters entered the suit shop room and started threatening with the dire consequences. It is also false to say that at least 10 or 15 people of the locality who are political backgrounded tried to enter the shop room. It is equally false to say that the now my lord will kindly then my lord will come to the underlining portion. The defendant states that he is the owner of the shop under the name and style of Tultul Bhandar and is running the grocery business in the said shop room since 1984. Now my lord, I will take my lord to their plaint where they have said annexed only 2025 trade license. Where I and to this one
With that,
my lord will kindly allow me to first place how many documents I have shown.
Yes.
Of my possession since 2018. Nothing was considered of this objection, not even a single document. Now, my lord will kindly see. 19 and the valid trade license issued by Dongoria Raipur Gram Panchayat. The defendant further states that his shop room is situated in Dongoria Chaurasta and he is the member of Dongoria Chaurasta Basti Somiti and he's been paying remuneration to the night guard and a valid receipt has been issued to Dongoria Bebshai Somiti. The defendant states that the plaintiff falsely lodged the complaint. Now, my lord, 6, 5 and 6, which they were again placing from their petition. Now, my lord, how I have dealt with that. Paragraph 8. The statement made in paragraph 5 and 6 of the petition that when the plaintiff intervened to prevent the violation on the reminded the defendant of existing order that were met with the threat of dire consequences or the police could not do anything except lodge an FIR. Now, my lord will kindly come to the next page. Order, they are flouting the order. The plaintiff is running the business are false and are denied. The defendant states that the plaintiff has no right, title or interest and possession over the part of the defendant's shop room Tultul Bhandar, which is situated on the rights of the main road, so and so. So the claim of the plaintiff is vague. Now, my lord, I put on record. Now, my lord will kindly see my annexures. Lordship will kindly see the annexures. First annexure, my lord will kindly come to page 87. My vis-a-vis to the document which they have shown. My trade license is 21/3/2024. Then, my lord will kindly come to page 91. My document, এটা বাংলায় কত লেখা আছে গো এটা?
এটা 21/2/2023 but
my lord will kindly
2024, that is of March of 2024.
Yes, my lord. Now, page 90, my lord, my document of 2023.
Yes.
Then lordship will kindly come to page 90. Then my lord will kindly come to my balance sheet at page 95 of Tultul Bhandar. Page 95.
Page 93.
93 is lordship.
For income tax returns.
Yes, lordship, which is of 22/23.
Yes, and this is the
balance sheet. At 95. This is also 22/23. So these documents were not considered by the learned trial court. Now, my lord will kindly come to page 89.
These are the income tax returns.
Yes, lordship. Now, my lord will kindly come to page 89.
And these are the bank statements.
Lordship, I will come to the bank statement. That is way back in 2018. Now, my lord will kindly come to page 89. এটা কবে 2016 lordship in Bengali numerics, my lord, I am bad. Page 89. Lordship will kindly see. এটা কি আছে? Dongoria
It is of 2017.
Yes. Now, my lord, these were the documents which were put on record before the learned trial court.
Under 151 objection.
Yes, and that was not considered. Now, my lord will kindly see one more point, my lord. So I was always in possession, and in my written statement also, my lord, which was before the learned trial court, which was filed in the month of March itself. Now, my lord, what happens, my lord? Knows, my lord. Ad interim order obtained, showing your plaint. My lord will kindly come to now, my lord. I am grateful for this, my lord. My lord will kindly come to the first. My lord will kindly come to injunction application on the what document they have got injunction.
Yes.
That is at page 28. The documents.
Yes.
দাঁড়াও দেখাচ্ছি একে. My lord will kindly see page 28. Injunction starts. Now, my lord, they say, my lord, if my lord kindly comes to 29. Statutory taxes payable for the business. The plaintiff is carrying on business under the name style of page 29, lordship. I just want to mirror
29, yes.
Yes. Statutory taxes payable for the said business. The plaintiff is carrying on business under the name and style of Tultul Bhandar, being wholesale, grocery and mudikhana. The plaintiff paid Gram Panchayat tax of 150 trade registration dated 29 September 2024. And the Gram Panchayat has stated trade registration certificate of 24/25. My lord, no document prior to that. No document, my lord, for 24-25, the document will be.
No, the trade registration certificate has been from 24-25 to 26-27.
Yes, my lord, because what happens, my lord? My lord, will kindly see. Today, for the financial year, my lord, they issue. So if I apply for trade license in 2024 November, it will be issued for 24 and 25.
Yes.
And my document was from 2017-18. The learned.
How this 25-26, 26-27 has
But
been
they have
issued?
mentioned in the plaint, and the ad interim order was granted on that basis. So, my lord, I am trying to say that ad interim prima facie case, balance of convenience, inconvenience, irreparable loss have been decided on the basis of document which are not older than 2024 September. And the ad interim order has been granted admittedly in the month of December. Therefore, his possession documents are as old as September 2024, not before that. And my 151 annexures are glaring at the face, and which were not even considered, which is quite visible from the finding of the order impugned. Just one line to my credit that I oppose vehemently, nothing else. So, my lord, 1/5 this injunction application itself.
Yes, Mr. Banerjee, do you have a better copy of page 34?
34.
Yes.
No, সাহেবের কপিটা কি লাগানো
I can show mine, my lord, what I have.
সাহেবের কপিটা
That
কি
is from his copy.
Yes.
No, but this left-hand column that
Yes,
Xerox,
yes, well, that Xerox has, yes, yes.
because
You can
the
ask him
name
to get it. This he will have. I can ask him to get it. You know. The dated 24th, 5th September 2024, I can see.
and what are these items?
Elaichi, Meetha Magic, Pass pouches.
Yes, and
Chaman Bahar and Chaman Bahar.
what is the
Mudi Khana.
It's a pawn shop.
No, it's a Mudi Khana, my lord. Mudi Khana has all the
item
groceries.
stores? It's a pawn shop. From the items.
I don't know what he stores there.
Yes, yes.
So, my lord, what I am trying to impress very humbly before my lord. So, at prima facie, when the injunction was granted on 18th of December, the best documents which they have of
Mr. Banerjee, the previous registration certificate can you produce? Because you are paying trade license fees for 3 years. So this is for 24-25. Earlier, it must be for 5-6 years. Constantly you are paying.
Your lordship is going back to my examining my plaint also.
Yes, yes. That's the very basis. When you are taking me to that extent, I have to.
I haven't not invited the court to
Yes,
go
because
to
you are trying to protect your possession.
Yes, not and the
That is
39-1-2
on the basis of, and you are saying,
lordship is looking
Mr.
at
Banerjee, you are
there
saying,
is no written objection to 39-1-2. But I can understand there's certain element of investigation, but 39-1-2 there is no injunction objection. This is to 151.
so you have got an order of injunction on the basis of your plaint case.
Correct.
On the basis of the documents.
So, today that one
Can you produce those documents?
Yes, yes, that I can produce. Before I don't know what is there. What was there, I'll produce. You know, that
my lord, 151, they were trying.
Must be there before you are, because you are
that I don't know. What
a
is
person
there
who
in
is carrying on business for long.
not in the plain.
The earliest one is being produced in an injunction application.
Well, I don't know. The plain.
You know, you always advise while drafting.
I don't advise here.
No, may not be in this case. So what's the art of drafting when you are obtaining an order of injunction? But the latest documents, what is the earliest?
Is to show that on that day I'm in possession. In my understanding, for an injunction that should suffice. But what is there before me, I haven't asked. And this thing that I was saying off the cuff, I'm carrying that judgment. If your lordship give me 2 minutes, I'll cite the different bench judgment 151 with police help. I was carrying it. My junior did not inform me. If your lordship desires, I'll just in 2 minutes after he finishes,
yes,
I'll trouble your lordship.
Nonetheless, my lord will kindly come to the plaint, which is at page 22.
Yes.
Now, my lord, the best documents which they have to disclose it under the plaint until unless they amend it later. Now, my lord will kindly come to page 22 where the plaint starts. And my lord, at page 23, the documents have been amplified. That is again 29th of September 2024. Now, my lord, what my case is. Now, my lord, what my case is, that my lord will kindly see the interim order, ad interim order was granted on 12th of December. It was valid till
18th of December.
I stand corrected, my lord.
Now I know the date by heart.
I am grateful for my lord. My lord, on 16th, the interim order was going to, ad interim order was going to be vacated or was going to expire. Now, my lord, on 14th, they go before the court and say that
Why
they
did
have
not file any written objection, Mr. Trivedi?
My lord, that's why I'm telling my lord the sequence of dates. What happened was 16th of January, I entered appearance, asked for taking time for filing written objection, and in the meantime, what they did was on February 2nd of February, 7th of February, they filed their 151. So when a person has filed 151 to dispossess me with police help, what will be my first chance? I will first gather all my strength to counter this particular problem which is going to take place, because it is with regard to contempt. So in order to diffuse the case or the allegations made against me in 151, which were per se false, I came up with all bunch of documents. Now, my lord, my question is, what was before the learned court below? There was 151 application. He was not deciding on the injunction application. Now, in the 151 application, which was there on 7th of February, nothing was stated that he was dispossessed. Now, my learned friend is championing for the cause that court was trying to undo what was wrong. Here, nothing, it is nobody's case. I have never conceded to the fact that I was not in possession. My learned friend's argument starts from my concession that I was never in possession, which is not the case. My learned friend is trying to argue that on a particular date, my lords, or any, for that matter of fact, any learned court of West Bengal or the court or India passes an order being satisfied in totality that I am in possession and on contest, and then I violate the other and he is dismissed, then status quo ante, and at least there should be a pleading, one line. There is no pleading regarding dispossession. Now, the learned trial court was on incision of that particular general diary which said that he was dispossessed on 14th. The learned trial court did not even venture into that document. How?
Where is that?
151 application?
Yes.
How did I get it?
No, 151
application, they had annexed that.
What?
That document. My lord will kindly come to page 79 of the petition.
Yes, this complaint.
Yes. And then the other complaint at page 80. This is annexed, appended to their 151. Otherwise, how I will be privy to it? And the FIR was also privy to it, because they have stated about the FIR. The learned court only went through the FIR, which does not say anything about dispossession. It was a very well-crafted FIR. It says nothing, because if my lord kindly goes through the section, because now I am also getting well versed with the criminal law. Now, my lord, the FIR is
under what sections?
I am telling my lord, under 223, which is disobedience of order of a public servant. 117(2) grievous hurt, 303 within bracket 2 theft, 351(2) criminal intimidation, common intention. No dispossession, no criminal trespass, no house lurking, nothing. So there has been police also, and the learned trial court also did not delve into the handwritten thing. Everything was crafted in a manner that as if I want to. So, my lord, my case is under 150. No, my lord is not traveling beyond anything. It was my case at the very first instance under 151 that, and also in my written statement, that I am in possession, all my documents were on record. The learned court below ought to have considered my documents, because my lord will kindly see the cardinal principle of granting 151, which has been passed by this honorable court in cases of interim orders. The judgment of my lord Justice Dipankar Datta, which is followed till 2024, my lord, the cardinal principle.
That took into consideration the
points. Paragraph 15. Paragraph 15.
Yes.
Lordship will kindly come to paragraph 15. Agdom, please. One for you.
Yes.
Sir, Ami jantam na police will help. My lord, will kindly come to paragraph 15, my lord.
Yes.
8 2020. Paragraph 15. No, 8 second. No, 8 আমার favor है ना, আরেকটা আছে দাও। My lord will kindly come to paragraph 15. এইটা আলাদা আছে, এটা আরেকটা দিচ্ছি তোমায় দাও। Lordship will take up. May I place, my lord? I had a copy. I'm just getting. It is well settled law that section 150 of the code is not to be resorted to when the court provides a remedy for the aggrieved party. An order of injunction, if not complied with or obeyed by a party bound by such order, may be executed in terms of section 36, that is execution of an order, my lord knows, of the code.
Kindly come to paragraph 18.
Yes, my lord. No, my lord, kindly allow me to place the last but 5 lines of this paragraph. It is therefore recognized, my lord will kindly, it is therefore recognized that in appropriate cases where the facts are not in dispute. Now, my lord, does this order qualify these 4 lines? I am out of this court. Where the facts are not in dispute, I have disputed it vehemently in my written statement and in my objection regarding possession. Then, my lord, the court is satisfied that the party is bound by the order of injunction has violated and disobeyed. Where is that finding?
Kindly come to paragraph 18. That is
This paragraph 18. The defense of the petitioner to the application under section 151 of the code has been noted in paragraph 8 supra, since the petitioner has denied the material allegations leveled against him by the opposite party number 1. It was obligatory for the trial court for arriving to a definite conclusion on rival claims to allow the parties to elude evidence. That could be led if an application for execution been filed without appreciation of evidence that the parties could lead. It seems to be impossible for the trial court to return a specific finding that the petitioner indeed indulged in the acts of commission amounting to violation of disobedience to the order of injunction and or is an attempt to violate, disobey. The trial court did not record any such specific finding, justifiably so, but proceeded to order police help merely by relying on the allegation made by the petition opposite party number 1, as would be evident from the portion of.
I wanted to know from Mr. Banerjee, where is that finding?
Now, my lord, another judgment which was passed by this honorable court.
In terms of this
2020, my lord. So, my lord, here, my lord, what?
Not merely allegation. It's not so simple to pass an order of 151.
Now, my lord, as far as during 4 corners of that order, nothing has been considered by the learned trial judge. Neither the police report, neither the documents by them, neither the document by me. Yes,
you want the copy of the order? You can.
No, my lord, I have got a copy, my lord. I'm handing over.
Because I did not refer to that. I was only asking you to satisfy me on those principles. What are the guiding principles for allowing 151? Not so easy. Merely coming saying allegation, police will right and there, and more so in a case of possession. Very difficult because there are cases.
Now, my lord, another judgment, lordship. Yes. Now, my lord, another judgment of. Now, my lord, another judgment which was again the honorable single bench, coordinate bench of my lord, which was relying on this judgment on the same finding, my lord. 2020 SCC online Calcutta, lordship. Lordship, here, my lord, paragraph 11, 12, 13, 14 and 15 are relevant.
11 to 15?
Lordship.
Anything more, Mr. Trivedi?
My lord, here, my lord, nothing on the factual matrix, my lord, and my lord, what I am trying to impress, my lord, just recapitulating everything, my lord, just the garnishing on the cake. My lord, here, my lord, there is a case where we both are brothers, full blood brothers. We are enjoying the same property. There is a dispute with regard to shop. Now, my lord, the document, the best document which at the time of ad interim injunction could be produced by my learned friend's client was 2024 trade license. Now, my lord, I had shown, and then, my lord, I entered appearance. That was the first date when I entered appearance in the month of January, because that is the returnable date. Just before that, and I take time for filing my written statement and my written objection. Before I could gather all the documents as application under section 151 comes. Then after that, aided by another application for police help before this honorable court. But I'm running from pillar to post. Now,
anything more, Mr.
No, nothing else. So,
yes, Mr. Banerjee, you want tomorrow. You wanted a day to cite some decisions.
That I have. I'll just show that. I'm carrying that.
No, if you want to, you said you want time to
No,
do
Milord,
research work.
I'll
If you want, I will give you time.
No, Milord, I'll finish it today. I have understood, Milord, that Your Lordship will just have a look at.
No, Mr. Banerjee, please don't take it that I've made up my mind. That is why I'm giving you. If you want, I can give you time to make research work, to cite decisions, because this is an issue which has to be decided. That is why I'm telling you. Don't take it that I've made up my mind. This was only to bring out this because I wanted.
If I made some impertinence, like Your Lordship said, Your Lordship was
Because
here.
I thought that he will try to distinguish this judgment.
I will.
That is why, yes.
I'll have to. Then Your Lordship will just keep it sometime next week. Can I ask for?
Next week?
1 week. Well, I am only out of possession.
Yes. He is also out of the possession. That is why, Mr. Banerjee, I have kept it as a special.
I understand, Milord. If I
monthly list, that's why.
Well, goods are lying there, Milord.
Yes,
In order to
Mr.
safeguard myself, I have only asked it to put.
He was in possession. He is the affected person, and you are not in possession from, admittedly, from 14th of January till 30th of June. You can take it. 1st of July. So for this period, you are not in possession.
My lord,
So admittedly,
it's a Mudi Khana, Milord. Mudi Khana grocery shop. I have only opted that
will lose his customers, either he or you.
Milord, my goods are,
I understand.
my goods are perishable.
10th Thursday. Could I come on Thursday, Milord? 10th?
Yes, Lordship. 10th, Milord.
10th. If it otherwise is all right with Your Lordships.
10 তারিখে কি অবস্থা?
যখন জজ বলবেন। Whenever it's convenient for Your Lordship on the 10th.
Later part of the day, starting from 4.
That's the best time.
I have experience.
কত 10
No, that will be the 4 o'clock.
Yes.
It doesn't.
Yes, because I had kept it at 2 p.m. because the officers were directed to appear. So that is why I fixed this. Ashun. the advocate should
I'm here.
No, I think Mr. Banerjee will agree to that. Mr. Banerjee do not have any difficulty in that. I think Mr. Trivedi has some objections. Yes.
Very grateful, my lord.
I'm grateful, my lord.
Mr. Banerjee, don't take those observations. It was only to get some reply from you with regard to those.
It's actually much better. If there is some kind of an exchange, I also know what to answer. Much easier that way, my lord.
The interaction is very healthy because it's
Yes,
just
tolerance matters.
Very good.
Thank you.
I'm grateful.
P9. Item number 16.
Let it be kept with the record.
Copy of this, my lord.
Then make a photocopy and give it. File a copy. At the din photocopy.
Yes. Kindly come page 41. Lordship, the matter is, Lordship, I am the husband. My wife, Lordship, during the pendency of the application for decree of divorce, file application under section 36 for interim maintenance pendent till I. Now, Lordship, kindly come page 41. This is my affidavit of assets filed before the learned court below. That is monthly income I have stated 90,000.
So which order you are challenging?
Lordship, Lordship, I kindly come page, it starts from page 989.
Page 89, yes.
Lordship, the order dated 28th April 2025, directing the present petitioner to pay interim maintenance at the rate of rupees 30,000 per month. Kindly come page ordering portion.
This is the order under challenge, 28th of April 2025.
Yes. The ordering portion at page 96. 15,000 per, Lordship, per month.
Where is the certified copy, Mr. Mukherjee? Where is the certified copy of this order?
Lordship, the last portion, kindly come. The last page.
No, certified copy of this order. Page 89 is a plain copy of this order. Where is the certified copy?
Lordship, the 28th April 2025, order number 19.
Yes, where is the certified copy? This is not the certified copy.
That's the last portion.
What last portion? No, where is the certified copy?
Oh. So this is the server copy.
Yes, where is the certified copy?
But by ordering portion, Lordship, the certified copy has been.
You have to get the entire certified copy.
Certified copy.
Yes. Yes, page 89, yes.
And Lordship, kindly come page 89, the ordering portion. That is page 96.
Yes.
OP shall pay an interim maintenance allowance to the tune of rupees 15,000 per mensum each for the petitioner wife and for the minor daughter as maintenance pending till life. That is total amount of 30,000 payable according to the English calendar month and shall be payable within 10th day of every following month. The Lordship, this order shall be applicable from the such and such. The Lordship, the Lordship, the judge has not considered the income of the petitioner because it appears from the affidavit of assets I have disclosed, page 41.
41. Yes.
Kindly come serial number 3, details of the income of the deponent.
Yes.
90,000 approx.
This is your affidavit of assets?
Yes, my affidavit of assets.
What are you doing?
Lordship, I am the employee of Larsen and Toubro.
Show me your salary certificate.
Yes, 85 is the salary pay certificate.
85.
Yes. Kindly come net pay 88,064.
Net pay is
88,064. All deducting the income tax and everything. Right top, third column, right side, net pay. And this is the August 24, that is 90,000, 91.
Yes.
Now, Lordship, kindly come. Out of 90,000, what are my expenses? Lordship, the benefits of my daughter, minor daughter, on the monthly basis, I am regularly depositing 8,000. That is Sukanya Samriddhi account, 8,000. That is page 5.
Where have you disclosed your income from other sources? In the income tax return, you have claimed deduction under chapter 6A. Show me your other source income that you have disclosed in the affidavit of assets and liabilities.
Disclose kindly come page 41.
Page?
Starts from, this affidavit of assets starts from page 38.
Page? What are the EMIs which you are?
EMI, that is the house building loan.
Yes, how much you are incurring per month?
EMI I am paying. Page 88. Kindly come page 88.
Yes.
That is the 24,240.
So your monthly expenditure is 64,295.
Yes.
And what is your monthly investments for which you have got deduction of 1,50,000
LIC
under chapter 6A?
Yes, LIC 1531. Sukanya Samriddhi account 8,000. Lordship, Tata AIG insurance 1155. Axis Blue Chip Fund 2,000.
So this is your monthly expenditure with regard to the investments.
Yes.
And your other expenditures monthly?
Other expenditure, that is the Lordship.
Yes, sir, I want to know your other expenditure because I have to tally with your income. So 64 is these investments. A person investing 64,000 per month with a monthly income of 90,000, how he is running his show. I have to consider that.
হ্যাঁ আদার কিছু ইনকাম আছে
Has to be. Mr. Mukherjee, you are claiming deductions under chapter 6A of 1,50,000. Do you know what is deductions under chapter
Lordship,
6A?
this is the investment, that is the EMI I am
Yes.
paying everything. But Lordship, this is the
So this EMI is not with
88.
this EMI is not with regard to the house building loan. So over and above this, there is EMI of house building loan. There are your other expenses. Tell me that. Where have you disclosed? And what are your other income? There must
other
be some
expenses, the
other income.
approximate-
Otherwise, you could not have invested in this 64,000 per month. Health insurance and other insurance.
Lordship, kindly come page 38, my affidavit of assets.
Yes.
General monthly expenses of the applicant, rent, household expenses, medical bills,
How much?
transportation, 64,295.
Cannot be. Please take this chart which you have shown. Page 88. This is only with regard to investments.
No, investment along with Lordship the other expenses, medical other expenses.
Mr. Mukherjee, please kindly come to 85. How can it be? This is 64,000 with regard to these investments only. So you do not have anything to spend. Unbelievable.
Lordship, kindly come page 80. Kindly come page 80.
88.
Yes, 88.
Yes.
88. Lordship, the kindly come. My home loan is 24,249.
Yes.
This is the home top-up loan.
Yes.
Samriddhi account. This is the Lordship. This is the admitted fact.
Yes.
8,000 I am regularly paying. LIC. Now Lordship, kindly come last. This is mother's medical expenses. 70 years old mother.
Yes.
10,000.
And your household expenses?
That is a 64,295.
64 is not your household. You do not have any.
The total expenses according to this is I have explained. Now my
Mr. Mukherjee, show me your other expenses. These are only insurance, house building loan. You do not have to spend anything else.
Yeah, obviously, for
What is that?
myself, maintaining my.
Yes, sir. Show me that.
Lordship, it is minus to 90,000. The rest amount I will, Lordship, explain for my maintenance.
Show me that you have stated that in the affidavit of assets. Your monthly expenses.
My monthly expenses.
Yes, yes. And you are regularly filing the.
Yes, kindly come page 40. Deponent approximate expenses incurred on account of the dependent. That is 10,000.
That is mother.
Mother.
Your own expenses. You are silent. And you are an income tax payee.
I am income tax.
Where is your income tax return?
Yes, yes. I have given the income tax return also. I have annexed.
Yes, show me. Let me see whether there is non-disclosure of other sources income.
Income tax return. Yes, yes. I have Lordship. I annex the income tax return.
Yes, yes. Show me. What is the income you have disclosed there? Yes, page 45.
Yes, page 40. Yes.
Yes.
লাখ 6,000 টাকা আপনার স্যালারি ছাড়া আর কোনো ইনকাম আছে?
What are these credits of 18,000 at page 48 in the bank account from Yes Bank?
UPI. Somebody has Lordship, they sent the money. I don't.
Yes, under what account?
Through UPI it has been paid.
For what purpose?
Explain
Explain the entry, credit entry at page 54, dated 28th of December 2022, 2,26,268. That is not your salary.
It is arrears. That is arrear in terms of salaries. Because it is Larsen and Toubro has credited this sum.
That is area salary.
Arrears.
So
this pay is a Larsen and Toubro.
yes.
Payment has been made through Larsen and Toubro, ICICI.
And this is the credit entry at page 62, 2,11,125.
That is also arrears.
No. That is not Larsen and Toubro. Don't say those without seeing those entries. Page 62,
yes.
24th of June 2023.
That's why I will. Subsequently, Lordship, the
Mr. Mukherjee, you have made an insurance for the daughter. So that is, the daughter has to be maintained.
30,000. So first of all, 15,000 from for my daughter, who is 4 years old. Now, Lordship, the standard
What is your position in Larsen and Toubro?
This is engineer, civil engineer.
Engineer's daughter, 15,000 is not required per month.
Lordship, possible. Lordship, kindly 30,000 I have to pay, 15,000 for my daughter, and 15,000 for my wife. That is the 30,000 gone.
90,000 is your salary.
90,000 my salary. Now, Lordship, the
That's the net salary.
Now, Lordship, what is the reasonable deduction? That is the house building loan. Otherwise, Lordship, if I stop pay house building installment, it will be auction. I will be homeless. 8,000 regularly I pay.
That cannot be considered while deducting.
But Lordship, I will, Lordship, kindly consider how I will, Lordship, continue my life.
By the order impugned.
What is that? Great.
18 months. I'm for the opposite party number 2, my lord. 18.
Opposite party number?
I've received instruction to appear under the opposite party number 1.
Is not the opposite party.
I'm for the opposite party number 2.
Oh, two opposite parties are there.
Complainant KMC and my lord the
This is KMC.
private.
You are the petitioner.
Yes. The demolition order has been
Demolition-
31st August 2023.
We finished.
Thereafter, I filed a writ petition, and the writ petition direction was given to comply that order. Thereafter,
Appeal is pending before the
No, my lord.
appeal is pending before the tribunal. Tribunal, after consideration, the stay has been refused.
completely
Which is-
suppression materials has been
And the
filed.
division bench, while passed an order, lastly, there seems that if there is single bench has passed an order saying that there is a terrorism upon the appellant if the during the hearing of the appeal. Division bench has said.
Where is the order of the special officer building?
Special officer building, my lord, inadvertently it has not been annexed.
Not been annexed.
You have a
completely
copy of that?
suppressed.
You have a copy of
Not
that?
Given to me, my lord.
My lord, tomorrow is the
My lord,
date
kindly
fixed for
see the
demolition.
The division bench order that has not been annexed in the petition.
Division bench order I'm giving.
Two writ petition, contempt, division bench order.
Thank you very much, my
Yes,
lord.
everywhere he failed. There is a demolition understanding now.
Oh, done.
Division bench has stated that the demolition should be done.
Kindly see the division bench order.
Order is
There
there.
has been stated
No, this division bench is against which order?
In the order of the learned single judge.
by Langas.
In the read court.
I filed a
Read court has demolished, read court has dismissed the writ petition.
Not dismissed, my lord. The writ court has not entered into not given me an interim protection and directed the matter to be kept pending. And thereafter, I have given the
Case
trust
number
to the-
41 is the single bench order.
There is no dismissal.
But your lordship kindly go through the appeal court order, man.
Yes.
Tribunal order.
Yes.
Your lordship will find everything. Everything has been discussed. Kindly see the building tribunal appeal court order where stay petition has been rejected with cost. Everything
50,000 cost. My lord,
A petition has been rejected with cost. But my appeal hearing is fixed.
What will be decided in the appeal?
Till my last bid, I should get a stay. My humble submission. The 6/8 is the date fixed for the hearing before that tribunal. Till such time, till the decision of the appeal court.
I had already decided, my lord, kindly see that order once. At the last of the revision petition, it has been annexed. 28th April 2025 model, my lord, kindly see.
Special officer building order is of 2023.
Yes.
If you let me see the entire order of the building tribunals.
And my lord, the Supreme Court in Kaniz Ahmed has already decided that unauthorized construction should not stand.
I wrote on record.
Yes, where is the sanction plan?
Well, I purchased it in the year 2022.
What did you verify at the time of purchasing?
No, but my lord, this is a slum area. This property is a slum area. This is a 80 square feet construction is there. For the only to living the only one person, my lord. This is a slum area. My lord, at least my humble prayer is that till the disposal of appeal.
Nothing. The division bench has said has refused that that you have failed to produce. Various opportunities were granted.
I have admitted
that is a submission. There is no sanction plan. Since you are the purchaser, you cannot produce that. That was repelled by the division bench.
And
What
my
remains?
cost, that cost 50,000, that is.
What cost?
The cost is
50,000 cost has been imposed, my lord, for filing frivolous.
Cost.
My lord, kindly take notice of this Supreme Court judgment at once. My lord, kindly record my submission.
What?
But that the
Then have to consider this matter on merits. So you are citing, I have to give you an opportunity to consider this. So what is the Supreme Court judgment? It says
unauthorized
appeal,
construction should not be.
but appeal, he has approached the appellate authority.
Very well, my lord. If the sanctions, they cannot be prayer for regularization. Cannot be.
So where is the prayer for regularization?
But they are praying for sanction, my lord, which cannot be allowed.
That is a
And that
different thing
sanction is not-
altogether. There is an order passed of unauthorized construction. There is an appeal as per the procedure. They have approached the authority.
Yes, my lord.
So what is the effect of rejecting the application for stay?
Yes. Sanction ही पाएंगे এটাই হলো কথা রেকর্ড করতে
This application. Yes, please,
Then I'll go to it.
copies of the.
I'm giving.
Yes.
Item number 19.
Well, make it not this week, my lord. I am not prepared.
My lord, I'm
Can you fix it on next week?
paying for leave to appear on behalf of the respondent municipality, my lord. Kindly direct the petitioner to serve the copy of the application.
Yes. Where is the order of demolition?
Well, the order of demolition is at from the page number 28 onwards. The complainant's house as well as our house, the three house has been asked for demolition.
All right, you have not served.
No, my lord.
Petition by the order. Next.
My lord, I am on behalf of the petitioner. Senior advocate Hiranlal Mujumdar could not be present before the personal inconvenience. Therefore, I am praying for time.
No, the second adjournment taken, I believe. The last time it was called on, the same thing of personal inconvenience was cited. That's my suit for specific performance.
Yes, no stay order is there.
No stay.
So I'm directing the trial court to proceed.
Mine.
Since an account.
For disposal of the my lord, expeditious hearing and my lord, disposal of the blood. Expeditious hearing of the title suit.
Of what?
Suit for declaration of title injunction.
Suit.
Yes, my lord. Before the land civil judge, junior division third court at my lord Baripur, and my lord.
Do I have any difficulty in taking up this matter? Yes.
You are only player, my lord, too.
Mr. Bhattacharya, do you have any difficulty in taking up this matter? Who is appearing in Paripur court? Who is your counterpart? And who is appearing for the other side?
You have the instruction, my lord. You lost it then, my lord. You lost it, my lord, today, my lord. Today you lost it, my lord, in the matter. And if you lost it, my lord, simply it only prayer to dispose of the miscase as well as suit.
On the
number 22. Withdrawn, my lord.
22, yes. Who is appearing?
Your Lordship, in this matter, I am appearing for the petition, Your Lordship.
Yes.
This matter is suit for declaration and permission filed on a respondent when the plaintiff has TS 119 of 2021 before Learned Civil Judge Additional Court Hooghly, Your Lordship. The father of the petitioner hearing of the petitioner on the land of case schedule to the extent of 0.15 acre plot number 2749 of 2015 belong to the petitioner of the petitioner defendant number suit number 1 to 9, Your Lordship. Proforma defendant petitioner deceased and proforma defendant 11.
What is the order in the challenge? What is the order in the challenge?
The order of the injunction and order of the mandatory injunction, which was dated on 2024, Your Lordship.
What happened after this order?
My lord,
order has been implemented.
This order.
What happened? What is your instruction? This order has been implemented.
This order was given by the.
This order, police was directed to open the padlock. What happened? Has the padlock been opened?
No, Your Lordship, padlock not been opened. Kindly see Your Lordship, 7, Your Lordship.
Yes.
After the respondent proceedings, petitioner filed a written objection inter alia stated that defendant petitioner was Gadadhar Surakar was joined on a 0.50% land.
Sir, I am asking you, has this order been implemented? What is your instruction? This matter is coming up after 1 year. What is your instruction?
My lord, I am paying before the title suit number to sit and stay granted when misleading granted court false evidence. Your Lordship, direction that passed has been fit and proper, Your Lordship.
What happened to the suit? What is the stage of the suit?
State of the suit, Your Lordship, hearing of the petition, the next date was given in 13 August 2025, Your Lordship.
Thirteenth?
13 August 2025.
For what?
Hearing for petition.
Which petition?
TS number, title suit number 24, Your Lordship, title suit.
What is the application which is pending for hearing? The
copy. Now, the department is of the view that it should be certified copy. But kindly grants me leave to because otherwise the matter will be proceeded ex parte by the learned arbitrator. And
file with signed copy.
Signed copy and I have given a date on 9th of this month, Wednesday. But there is an administrative direction by a lordship of 48 hours of gap from the date of I am being told by the department. Kindly give me leave that the matter to be listed on 9th. Otherwise,
why? What is the grave urgency that
the matter is fixed on taken up on 20 order passed on 27 June, fixed on 10th. 9th is the last date. That's the only difficulty.
Pay for an adjournment. If it is 10th, it can be filed. Nothing will happen.
Only thing may be listed on 9th. That's the only thing. The
Let it be listed on 10th. Nothing will happen.
No, difficult.
Arbitrator sitting is when? Arbitrator
in the evening. Only thing is
so
that
prior to that.
counsel from Telangana will be appearing, High Court at Telangana.
Yes.
They have requested they will be coming on 9th. We have to purchase the tickets.
That is,
There is no nothing on Millard. We will be moving expert. Millard, there is no difficulty.
no,
Anyway,
difficulties in all matters because there is a procedure. Unless it's at extreme urgency, it cannot
this
be
is
done.
Millard
It's
counsel.
not an extreme urgency. So when the order was signed,
Millard, we have received on 2nd of July.
what is the date of the order?
27 June received by the arbitrator on 2nd of July. Millard, today we are on 7 তারিখ 4 তারিখ Sunday, Saturday, Sunday we prepared it, Millard, and filed it today. There is no delay on our part. Advocates
10th, nothing will happen.
Millard, kindly, Millard, 9th May it appear any position. Millard, there is only I'll be losing my Millard face. Millard, with the Telangana, I could not fix it. Millard, a matter being a local advocate here. Millard, kindly give me that liberty. May it appear on 9th. Millard, Millard, one day, Millard, kindly give me that liberty. Millard, I'm filing it today. Millard, get the number. Give Millard. May it appear on 9th. I'll be.
If you could have obtained this leave in the morning.
No, they have refused. They have just after scrutiny.
When you approach them,
they have just told just.
When you approach them,
কবে ফাইল করেছিল সকালবেলায় তো
when you approach them, tell me the time when you approach them.
2 p.m.
Yes, you did not approach in the morning. You know, yes, you know that in the morning, if unless the leave is granted, it could have been done by this process. But the difficulty is that this is to be scanned and other things. They are taking time only for that.
No difficulty. My lord gives me liberty. Everything will be done. My lord, only my lord, even my lord leave may not be necessary. But I am told there is an administrative direction by a lordship.
Not an administrative direction. Not an administrative direction. It's only for that. Administrative direction. I have not passed any administrative direction. I have not said that it will appear after 72 hours.
My counterpart from Telangana will say you could not fix a matter on
this. So I have not passed any.
No, matter kindly give.
It's only in some matters they have come. They have said that these are to be scanned and other things for which it takes time.
I'm losing my face. Kindly, keeps it on 9th.
Could have mentioned in the morning. They could have done that.
Filed in the morning. They have told to come back at 2 for the after the scrutiny. He has gone at 2 o'clock.
Who said? দেখে পাঠান তো সকালবেলা গিয়েছে দুটো
Oh, till 2 p.m. there is a caveat check procedure.
Yes, so that is the procedure.
We have got on 2nd the order.
You are saying yes,
No, we have got on. There is no malpractice on my part. There is a caveat.
I'm not saying a malpractice. So caveat checking করতে দুটো পর্যন্ত লাগবে. When you presented for caveat checking?
কখন দিয়েছেন caveat checking এর presentation? 11:30.
Court starts at 10:30.
No, it has to be signed. Millard commissioner doesn't come. Millard knows the Millard difficulty.
9th করে দিন, lift to
Obliged.
9th.